Yes.
No, please, no. But, I beg to mention for item number 1, on the request of Advocate M. Islam, my lord, that I'm praying for password for the
Wait for a
matter.
few minutes. Wait for a few.
Lords, item number 20, my lords, I'd like to mention for upgradation of this item.
Inform the other side.
I have,
Lordship, the engaged council is in legs. So made a matter fix at 2 p.m.
Not at 2. We'll do it after admission side. Admissions and orders are over. Okay.
all right.
On the prayer of Mr.
B. Islam on behalf of M. Islam, my lord.
B. Islam. On behalf of Mr. M. Islam, I will counsel for the picture. Matter is adjourned for the day. Placed on 6th. Placed on 13th.
Deeply.
May it please the Lordship.
Reminder
This item
that,
will LCR is called for. But LCR has not received matter.
on 17/5, Lordship had sent a reminder for LCR.
Okay.
हो जाए. Hmm, 17/5 और पूछिए sir.
Mr. Sharma, what happened?
Lordship, I have need to take instruction, Lordship. At 2, Lordship.
Okay.
One second, I will.
By order did it. (3108) 2021. The court, while granting interim protection to the petitioner, also called for the records of FT/L/ case number 1241/2016, arising out of SP's case number 971/2009 from the Foreigners Tribunal, Nagaon, at Hotai. Hartsville district, Nagaon, presently Hotai. As the record was not made available to the registry by the said tribunal. That's good. The court, by order dated 17/05/2024, again directed to issue a reminder to the said tribunal for the same record. So serving a copy of the said order to Mr. G. Sharma, standing counsel from Department Assam, for his onward communication to the said tribunal at Lanka Hotai, as well as the Superintendent of Police. Office note dated 21/05/2024 reflects that the reminder was sent to the concerned tribunal on 25/05/2024 itself, pursuant to the order dated 17/05. Further, the office note dated 7/6/2024 reflect that the said records from the Fairness Tribunal of now 7 October 2026. Placed on June 26 for admission. Registry shall issue press reminder to the Superintendent of Police Board at Kothai, as well as the Fairness Tribunal, Nagaon 7, for the records of said FPL case. Wherein the evening has been ordered to 12/06/2019 was passed by the state tribunal declaring impediment for a for a separate 46 of post 25 Street. Failure on the part of the authorities concerned, including the Superintendent of Police Board, as well as the Fairness Tribunal 7 block to provide with the records of said passengers. Before the said is fixed with the register of this, the court shall consider to pass consequential order against the erring officer, as they are obstructing the court from the application of the matter. Also, they must comply with order dated 31/08/2021 after the is possible. While the petitioner is on interim break. Copy of this order also be furnished to MS Verma, Standing Council from Department Assam for purposes. Application number 166/2016. Furnace traveling section of interim bill. Additional granting interim bill. Report by order 2701/2010. 2020. 17. Yeah. Order 1503/2017. Declaring petitioner to be a foreigner in the stream of 166 to 25. But so,
Lordship, in this matter, date of bill 26 June. Lordship, I pay for on 27. 26, I have personal difficulty. Lordship.
Twitter 27.
Maybe the lordship. My lord, in this case, LCR received. May I pray for fixing the matter for hearing, lordship? LCR is here.
There is nothing, my lord, in this case. Nothing has been discussed, lordship, in the order. Hmm. Hmm.
Where is your link document?
Nothing, Lordship.
Where is your link document?
Not a single document.
Lordship, in this case, except the order of the landed tribunal, no other document are rather the recommended CW.
Right? Move. Itu kan orang hampir benar yang dibikin dokumen kali ini. Kan pakai ini bukan itu kan pakai ini peluru karena di berarti kita dia tapi pakai itu pun FDA 27 years. Okay. Down to it. One. Yeah. Link at robot. Eto dokumento di Google. W itu. Ikon W. Mungkin kita itu dapat dari sertifikat. Yes.
My lord, the opinion at page 10, my lord, which is under silence. From the opinion, it is clear, my lord, first point, that the learned tribunal, while giving this opinion, has considered some, my lord, evidence which were actually not relevant, not trustworthy, not even, my lord, admissible in the eye of law. So in absence of admissible evidence, the tribunal could not have passed this opinion in favor of the respondent. That is the point, my lord. And to demonstrate that, your lordship may kindly see from the opinion itself. We are not saying, my lord, the views of the tribunal are not, we are not challenging the views, but on what basis, my lord, what evidence the tribunal has passed that opinion, that has to be examined. Because under which, my lord, jurisdiction of certiorari, we have to examine whether the tribunal has passed their opinion on the basis of, my lord, the admissible evidence or not. If it is that evidence itself is not admissible, then, my lord, it cannot be accepted as a valid piece of, my lord, judgment or order or opinion. And that can be set aside by this one. As we know, my lord, the burden of proof in under these cases is in the proceeding. So she has to prove that she's an Indian, either by birth or by lineage, my lord, by bringing admissible, my lord, cogent and reliable evidence. So if we see the, my lord, opinion, the learned tribunal has passed this opinion and declared the petitioner to be Indian only on the basis of the oral statement of the, my lord, DW2 and DW1. My lord, first of all, if we go to the, for that, prior to that, your lordship may kindly see the WS man. What she has studied in her WS. Para 3 of the WS, my lord, it is in record. Para 3, it is said that the OP is a citizen of India by birth. But she has not produced any, my lord, evidence that she was born in India and she is Indian by birth. What is that evidence? That evidence is not. There's no evidence to that effect. She has born and brought up in Indian soil at village Porus,
Purva.
Porwas, Porua, and Mousa Holishwar, but date of birth is not mentioned. That is the first para 3 statement. Then she has studied in para 4 that her father is late Ali Hussein. Then para 5, she has studied that the father shifted to Hitor Suki village of Mouja Dhiru Hoirappat. Then, my lord, para 6, she has stated that she has elder brother, namely Abdul Rashid, and his name appeared in the electoral roll. Then para 7, she has stated after death of his father, the elder brother shifted with his family to the resident. My lord, in para 6, he has also further stated that along with the parents, the brother shifted to Vitor Sutia Moja, Vitor Suti Gaon, along with parents. And para 7, he said, after the death of the parents, after the death of the father, he shifted, this brother shifted to another village, namely Gorisinga, Gorsiga, Bihia. Now, he has exhibited 4 documents, my lord. 1966 voter list at Exhibit A. Exhibit B is the 1993 voter list. Exhibit my lord A, 66 voter list. The petitioner, the proceedee has shown that Ali Hussein was a voter in that voter list. My lord, if your lordship may kindly see the Exhibit A, that is not with me, that is in record, my lord. The Ali Hussein, the father name is Ali Hussein, projected as he is the father at Orua village in 1966 voter list, 37, age was 37, son of Laljan. And the next voter was Mamina Nessa, wife of Ali Hussein, age was 30 years. That was in the voter list of 1966. Now, interestingly, neither in the WS nor in the evidence says stated when did father die or when did mother die. This is very much necessary because after 66, there is no documents of her parents. This aspect was not considered by the tribunal. But your lordship may see, after 66, there is no documents of her parents. And she has nowhere stated when did her parent died. Now, tribunal cannot presume that parent died in so-and-so or this year, that year. From the WS in evidence, it is clear all this vague statement, all are vague statement. The DW2, as I have already written, para 7, DW, WS, she has stated, after the death of the father, elder brother shifted to village Gorsinga, Bihiagaon. When did shifted? When father died? These are not specific. These are all vague. And one thing it can be presumed, my lord, that this shifting was after 1993 from the voter list of from the Exhibit B, the second shifting, my lord. From Exhibit B, it is a voter list of 1993. If your lordship go to the records, it is voter list of 1993, projected to be the brother of the petitioner. Name was enlisted in that voter list, Abdul Rasid. It was in Vitor Sutia Gaon. That means till 1993, the para 7 statement was not there. But that means till 1997, brother was not shifted. And if father was not died, we can presume that much only. That means because in para 7, she said, after the death of the father, brother shifted from that Vitor Sutia Gaon to Goresinga village. So it can be presumed 1993, father was there probably. After 1993, well, the father is no more. Because now, from 1966 to 1993, where is the list of parents, voter list of parents? The petitioner, the projected brother who came before the tribunal and adduced evidence, he was 30 years in 1993. And my lord, he became eligible in he was 1993, he was eligible in 1985 also, 83 also. His name should have been there in 83, 85, 89. There were voter list. And if father was alive, My lord, from para 7, it is clear that father died. Father cannot die prior to 1993 because 93, the petitioner was there in my lord, Bhitor Sutia Gaon. So it is, there should be voter list of 1990, my lord, 1989, 85, 83. Those are not there. Why those were not produced? Because these are not the original persons, my lord, whom the petitioner claiming is parent. These are not the original persons. What they do? It is very difficult to, my lord, very difficult to find out, because that's why, my lord, it is burden is given on them. A person who come after 1971, he can come and go to someone else, someone that I may be allowed to take your name as your brother, son or daughter. Someone may adopt that someone. There is no documents. If I pick up a documents of 1971 and say, ask someone that please allow me due to some consideration, under some consideration, my lord, he may allow, okay, you may become my brother or sister. I have no objection, but you have, then his name can be entered in any time in the voter list. That is not possible on the part of the state to find out, yes, whether this nexus was there or not. But from the conduct, from the documents, that's why my documents, only documents were generally necessary for determining this issue, so that this can be found out. My lord, if the petitioner could produce the voter list of 1971, 66, after 66, there is no voter list of 71, no voter list of 83, no voter list of 85, no voter list of 89. If she could produce all these documents, along with brothers, sisters, petitioner, the proceeding, and the parents, because from para 7, it is descendable that the parents were there, father was there after 1993, then why these documents were not produced? Showing the name of the brother along with parents, showing the name of the brother along with sister. Why these names, these documents were not produced? These are, that's why, it is very difficult for the state to find out that if there is any nexus. Somebody may come today also, and he can pick up a documents of 1971 and can claim that I am the son and daughter of so and so. And interestingly, the villages are also different here. So from the evidence in WS, it is clear the old statements are vague. There is no specific statement. When did the father die? When did the mother die? Why the father has no, why the brother has no link documents along with parents? Why the petitioner has no link document, the proceeding has no link documents with the brother? Nothing has been explained. Nothing has been explained in both WS as well as in the evidence. Now, the proceeding has brought these three documents. From these documents, these three, and another exhibit C was the voter ID of projected brother, exhibit C. Exhibit D was the voter list of 1997, where the petitioner's name was shown as voter, but it was not a certified copy. The 1997 voter list was not a certified copy. And in 1997, petitioner has shown that the proceeding has shown that her name is appearing in voter list. Bijoy Kua Sapuri at the age Sapuri at the age of 27 years. If she was voter in, my lord, she was 27 in 1997. She should have been a voter in 1993. Why these are, my lord, the statements are necessary? She has nowhere stated when she got married also. If she got married prior to 1993, that was a different issue. But if she got after 1993, the brother should have, the proceedings name should have been there, along with the brother in 1993 voter list. This cannot be presumed by the tribunal. This is to be adduced by them only, madam. In absence of these documents, the tribunal, how can the tribunal presume that she is the brother of the petitioner, the proceedings, the sister of the, my lord, Ali Hussain, Abdul Rashid, whose name was there in 1993 voter list. So only these 4 are the documents, and from these 4 documents, my lord, it cannot be ascertained. The simple thing is, it cannot be ascertained that the proceedee is the daughter of Ali Hussein of 1966, who was resident of Borua village in 1966. We want that much only. By any documentary evidence, there is no documentary evidence to show that the proceedee is the daughter of Ali Hussein of voter list of 1966 of Borua village. There is no evidence except the oral evidence of DW2. My lord, it is settled position of law that the oral evidence, in absence of any documentary links, either to the petitioner or to the parent, has no evidentiary value in the proceeding under foreigners tribunal. So if that is so, the tribunal has committed gross error of law, which is apparent. And my lord, the tribunal has passed this opinion in absence of any admissible evidence showing that the proceedee is the daughter of this Ali Hussein of 1966. So this opinion, therefore, is bad in the eye of law, is liable to be set aside. My lord, oral evidence quoted, my lord, we have numbers of judgment.
Yes, please tell.
Yes, my lord, the oral evidence, if you refer the oral evidence, my lord, I will refer generally to judgment. 3 judgments are there, numbers of judgments. In fact, my lord, the first one is 1900 of 2019. 1900 of 2019. It is clearly said, para 6 in that of judgment. Similarly, in para another judgment in 4020 of 17. 4020 of 2017, my lord. There also para 6 input. There also the DW2, the projected father Kim, and in absence of documents showing his relation to the petitioner, the oral evidence of the DW2 was not accepted. The father. Similarly, another judgment of this honorable court, my lord, that is 2018 3 GLT 118, my lord. 2018 3 GLT 118, Bijoy Das versus Union of India.
One is 1909.
1900, man. 1900 2019. Another is 4020 2017, my lord. And next, 2018 3 GLT, my lord, 118. In both this case, projected father and mother came.
The judgment of 2018 3
Yes.
GLT,
Yes.
Mr. Paying, you are relying on para 17.
118, my lord. Page 118, yes, para 17.
Anything else?
Your lordship, and in the para 11 also, there is some with regard to WS that as it is in the same judgment. Para 11 man. Inadequacy of inadequate
What
WS.
else?
Why this is necessary for? Because identity of the petitioner is proceeding is very much necessary. To identify the proceeding, he or she has to give the details of her personal details, her date of birth, her place of birth, her parents' name, her grandfather's name, her brothers and sister, if any. Everything has to be multiple. Then only identity can be, we can identify, yes. In absence of those documents or those evidence, the identity is not clear. Identity of the person is not clear. So it cannot be. So from this matter, it is clear. And from the reading of the opinion, it is clear that the proceedee could not adduce any documentary evidence to link herself to her projected father. However, she tried to link herself to the projected father by way of oral evidence of DW2. And in absence of that, apart from that, there is no other evidence. And it is settled position of law that in absence of any documentary link to the petitioner, no oral evidence in the foreigner's proceeding is accepted as a valid piece of evidence. So if it is so, the learned tribunal has passed this opinion without any admissible evidence, which can be interfered by this honorable court under certiorari jurisdiction. Because it is settled position of law. My lord, we are not saying the tribunal opinion of the tribunal's view. We want that tribunal view may be different. We may differ the tribunal's view, but tribunal has passed this opinion without any evidence. My lord. If it is passed without any evidence, without any admissible evidence, it can be interfered. And it is, we have to mind, my lord, that the burden is the proceeding to prove that she is not a foreigner, she is an Indian. And in absence of, if that is not followed, if Abdullah, my lord, in similar circumstances, this honorable court, Abdullah, this is WPC, my lord, 2641/2017. 2641/17. The state of Assam versus Mohabali. This is reported. It's reported. This was decided on 29/5/2018. And this is reported, my lord. My lord, page para 14, some discussion is there. There in that case two crucial documents which say that Ahed Ali so and so was the son of so and so, alias Exhibit H and Exhibit I. Exhibit I is a certified copy of 02/06/2004 issued by one Ahmad Ali Gaubura, certifying that Ohad Ali was the son of so and so, but Ahmad Ali did not appear before the tribunal along with contemporaneous record, exhibit A as well as contents thereof. Therefore, the exhibit was not proved. That part we find it Kawamura had embossed that is a different issue. Now, such authorized unuse of state emblem have rendered exhibit A as inadmissible in evidence. In that case, in fact, some more evidence were produced and used, my lord. Now, my lord, your lordship may kindly see para 16.
Yes.
Para 16. Your lordship may find it next, my lord, after the quotation of the 2013 1 GLT 809, because I read the entire paragraph, my lord. On the other hand, from the impugn order, we find that after narrating the case as projected by the respondent, tribunal observed that state did not examine any witness and failed to adduce any rebuttal evidence. That was in that case. Therefore, tribunal ensured the reference against state. We are afraid an approach taken by the tribunal is contrary to the law laid down by the full bench in court, bench of this court. In state of Assam versus Muslim Mandal reported on so and so. Now, madam, under this part may be considered for this case, purpose of this case, madam. Under section 9 of the Foreigners Act 1946, burden is on the proceeding to prove that she is not a foreigner, but a citizen of India, and she is not a foreigner, but a citizen of India, and this burden never sits. The burden has to be discharged by the proceeding by adducing evidence which are admissible, which must be proved, and which must have relevance to the fact in issue. This thing. From mere filing of documents without examining its admissibility and without documents being proved or without examining its relevance, it cannot be said that the proceeding has discharged its burden. Now, in the present case, my lord, the proceeding has adduced evidence of DW2. Apart from that, there is no admissible evidence, and that DW2 is not a, my lord, from the judgment of this honorable court, it is settled that the oral evidence of DW2 is not admissible evidence, because he could not produce DW2 could not produce himself, my lord, any documents to link himself to the projected to this my lord sister, nor to the parents. She could not produce. So my submission is that in absence of any admissible evidence, the proceeding would not have, the tribunal would not have passed this opinion. So it is bad in the eye of law. So it may be set aside and may be interfered by this honorable court. That much only.
Yes, Mr. Hussain, you are here as an amica. You have to add anything? Yes, no doubt. The proceeding report before the proceeding is projected brother, elder brother also report. Proceeding in her written statement indicated that name of her father appeared in the voter list of 1966 from the village Porua.
Yes.
And later in 1993, name of her brother figured with his wife as son of Ali from a Bhitorua Gaon, right? Bahotia Gaon. Then her name figured in the voter list of 1997 with her husband. Now, the documents have to be reliable, no doubt. Let us assume these are all certified copies. How the petitioner could have connected to that she is the daughter of Ali Hussein? Where is that link document? Do you want to say that as because the projected brother has said that she is my sister and I am son of Ali and my EPIC card is in the name of my name showing as son of Ali Hussein. So that is the connection. Is it enough? Is it enough?
Lordship, as per section 50 and 51 of the evidence.
Now, it is the burden of the prosecutor to show that she is the daughter of Ali Hussein,
Yes.
right? How she has linked herself with Ali Hussein?
My lord, this is the evidence under section 50. Under section 50, his evidence can be considered, Lordship. And going through the all documents and evidences, Lordship, the learned tribunal brought a judicial view, Lordship. And on the basis of the judicial notice, the petitioner has been declared, Lordship.
What is
And
section 50
everything-
of the evidence, sir?
Everything has been discussed at page 11, Lordship. Page 11. Opinion starts from page 10.
Hmm.
Uh,
Yes, please tell us.
page 11, Lordship. OP DW1 and her elder brother, namely Abdul Rashid, have adduced their oral evidence. The OP DW has exhibited some documents such as Exhibit A, voter list of 1966, Exhibit B, voter list of 1993, voter ID, Exhibit C, Exhibit D, voter list of 1997. Hard argument of learned counsels of both the parties. OP DW1 has deposed in examination in chief that she was born and brought up at village Porua, PS Tezpur district Sonitpur. The DW2 Abdul Rashid, younger brother of the OP, has also deposed that OP Salama Khatun was born at village Porua. In the cross examination, OP and DW2 have deposed that they have not submitted the birth certificate. OP certificate of OP Sulema Khatun. There is no documentary evidence to prove that OP Sulema Khatun is born at village Porua. Lordship, the OP born in village Porua, this is under their special knowledge, Lordship. And regarding birth certificate, Lordship, the learned tribunal has calculated in the last para that OP was born in the year 1971. And at that relevant point of time, Lordship, your Lordship also knows that birth certificate was not mandatory. And these persons are all illiterate person. We cannot also expect to have any documentary proof regarding their birth or death, Lordship. Then Lordship may kindly see next para. The OP, DW1 and DW2 have deposed that their father's name is late Ali Hussein, alias Hussein, and he was a resident of village Porua, PS Tezpur district, Sonitpur. The exhibit A is the voter list of Ali Hussein, which has revealed that Ali Hussein and Minia Nehru are voters in the year 1966 under 77 number Tezpur LSC, village Porua. It appears that parents of OP were present in the year 1966 as resident and voters of village Porua. As per the voter list of 1993 of Abdul Rashid, DW2, he was 30 years old. It appears that he was born in the year 1963. The OP was born after 1963. The OP DW1 has stated that she is now 45 years old. If that being so, OP was born in the year 1971. At that time, parents of OP were present at village Porua. In view of the above, I have found that OP was born at village Porua after 1966. Her parents were present as citizen of India. I am of the opinion that OP is a citizen of India. She is not a foreigner coming to Assam after 1971. In the report of the IO, there is no mention about address in the country of origin. It means there is no mention of which, from which country OP has entered India. Lordship, the learned tribunal has taken judicial notice of the death and the connection of the OP and his brother, Lordship.
Now just tell us from the written statement or from the oral evidence of the proceedee or her projected father, where from we will get that the parents of the proceedee were available at village Porua in the year 1971.
Lordship, they have placed some documents,
No, no.
Lordship.
Where from? Because there are only 4 documents. One is the voter list of 1966 of one Ali Hussain at from village. Another voter list of 1993 of projected brother. Then the EPIC of the projected brother. And the 4th is the voter list of the proceedee along with her husband. These are the 4 documents exhibited before the tribunal. Now, what is the basis of which the tribunal came to the finding that the OP was born in the year 1971 at village Purva, and wherefrom he has come to the finding that OP's parents were available at in the year 1971 at village Purva. From where?
My lord, OP produced some,
These are the 4 documents.
Lord,
There was no other extra
okay.
document.
Documents are from village Porua, Lordship, where the father, parents' name of the OP.
That's right.
Yes, Lordship.
There is a voter list of 1966 in the name of Ali Hussain from village Purva.
Yes, Lordship.
Now, where is the basis, on what documents, or on what evidence the tribunal came to the finding that the proceedee's parents were at village Porua in the year 1971? What is that basis? What is that evidence? Where is that evidence laid by the proceedee?
Lordship, OP exhibited is a voter list of 1966. And that document shows that the father of the OP was a resident of
We do
village.
not know father or not, but one Mr. Ali Hussain
Yes,
was
Lordship.
there in the 1966 at village Purva. Now,
Uh,
how did the tribunal came to the finding that Said Ali Hussain was available at village Purva in the year 1971?
The document says, Lordship,
Which document?
the voter list of 1966. And
1966.
his statement and the OP's statement made in the WS and evidence laid before the learned tribunal by DW1 and DW2, Lordship.
Which is that particular? Kindly show it to us. Which is that particular statement or particular document that led the tribunal to come to the finding that the petitioners or the proceedees' parents were at village Purva in the year 1971?
And Lordship, these things were also not disputed before the learned tribunal. These things, my learned friend is submitting regarding the documents. Some documents were not produced in between 66 and 1993. Some documents. And
No, see, the state here has filed in this writ petition stating that the order passed by the tribunal is without any admissible evidence.
Lordship.
Right. So that is why we're asking you, show us from the record that the petitioner, or sorry, the proceedee's projected parents were alive and were at village Purva, India, 1971.
Lordship, certified copy of voter list of 1966. My learned friend is saying that this is not admissible document. I don't know on what basis my learned friend
Forget
is.
that. We are
Yes,
asking
sir.
you now, Mr. Hussain.
These are admissible documents, Lordship.
No.
Voter list of 1966
See,
and
we have understood there is a voter list of 1966.
yes, sir.
Now, on what basis the tribunal came to the finding that said Ali Hussain were available at village Purva in the year 1971? What is the basis? There has to be some document.
Yes, sir.
Which is that? Was there any voter list of 1971 available before the tribunal adduced by the proceedee? Now let us assume the statement of the proceeding before the tribunal. She deposed before the tribunal that her father expired 10 years back. Her deposition was recorded in the year 2016, July 2000. So 10 years back, sometime 2006. So if that is to be accepted, and the evidence of the proceeding that after the death of her father, her elder brother shifted to another village. Right? So up to 2006, the name of projected brother of the proceeding, Abdul Rashid, should have figured along with his father, Ali Hussein. Right?
Yeah.
Very. Only year in the 1993, Ali Hussein, somewhere from we do not know, name
Document,
figured in the voter list. That too at the age of which year? 30 years. So, though he was eligible to vote at the age of 21 years. That means by 84, he was eligible to vote. But his name figured only in the year 19.
Lordship,
Yes,
accept the order of the tribunal. No other document is there with me, Lordship. Even the,
Go to the record. Sharma.
and what is there in the record, those are also not available because
Go through.
uh,
I have asked it. That day only we have passed an order asking both of you to go to the record. Last occasion we allowed you
Lordship,
on 3rd of June.
I paid for a Xerox copy of the document. Lord.
Cannot give. That's why you submit it from the record. The record is before you now. Or we'll take it after 15 minutes. We'll hear Mr. Das. Where is Mr. Das? That matter is parted.
Lordship, beyond this record,
Go to
the
the records and submit after a few minutes. We'll hear Mr. Das. Yes, Mr. Das.
My lord, I have relied upon one of the revision bench case of Supreme Court, my lord. This is Abdul Quddus. In that case, my lord, it has been ruled that foreigners terminal cannot redetermine the citizen status. Bar of residence would apply as foreigners terminal is a constitutional. On the
Can
ground, I
you
have
give us that judgment? Citation, please.
Yes, my lord, 2019 6,
Supreme Court cases 604.
This is
Abdul Quddus.
Abdul Quddus.
Yes, ma'am.
Yes, ma'am.
Which para you are relying?
Hello. Hello. Kuntu Pradesh.
Well, third para, my lord. 23 para 23, my lord.
Next para.
23. I don't know.
Please take your seat. Verma. Iya, mau kumbata ke puru kita pakai. Itu tiru. Yes, Mr. Pine, kindly read para 23 of the Abdul Puttur.
Yes. My lord, we are not disputing that that is aspect, my lord.
Kindly
Because,
read that fourth.
yes,
Come.
23, my lord. The procedure prescribed by the post. The procedure prescribed by the post 2012 amendment under the 1964 mandate compliance with the principle of natural justice. All the allegations and grounds are required to be served by the tribunal in the form of show cause notice in the person who is alleged to be a foreigner. Thereupon, the person has to be given a reasonable opportunity to file representation and also produce evidence. The tribunal has been authorized to consider and allow prayer for production and examination of the witnesses, which can be refused if found to be vexatious or made with intent to cause delay, etc. The evidence produced by the superintendent of police can also be recorded. The person concerned has to be heard before the tribunal gives its opinion. The person concerned may appear in person or can be represented by a legal practitioner or an authorized representative. Opinion is to be given within a period of 60 days after the reference from the competent authority. No doubt, the rules do not prescribe and require an opinion of the tribunal to be a detailed judgment. Nevertheless, it is obvious that the opinion rendered must state the facts and reasons for drawing the conclusion. It is a decision and an order. It is a decision and an order. Fixing time limits and recording of an order rather than detailed judgment is to ensure that these cases are disposed of expeditiously and in a time-bound manner. The opinion by the Foreigners Tribunal is a quasi-judicial order and not an administrative order. The expression quasi-judicial order means a verdict in writing which determines and decides contesting issues and questions by a forum other than a court. The determination has civil consequences. Explaining the meaning of quasi-judicial body in Indian National Congress versus Institute of Social Welfare, it was held that when any body of persons has a legal authority to determine questions affecting rights of a subject, rights of subjects and duty to act judiciously, such body of persons constitute a quasi-judicial body and decision given by them is a quasi-judicial decision. It would also be quasi-judicial order if the statute empowers an authority to decide the lease not between the two contesting parties, but also when the decision prejudicially affects the subjects as against the authority, provided that the authority is required by the statute to act judicially. Further, with differentiates an administrative act for the quasi-judicial act is the quasi-judicial body is required to make an inquiry before arriving at a conclusion. In addition, an administrative authority is the one which is dictated by policy and expediency, whereas a quasi-judicial authority is required to act according to the rules.
Come to the issue. Raise
Yes.
that particular.
This, the para 23. This, my lord, actually this,
Mr. Das, you are relying on para 23,
Yes, sir.
the res judicata issue.
Yes, sir.
Which para?
It is in my petition, madam.
Mr. You are relying on this Abdul Quddus case to show that res judicata matter.
Yes, madam.
Show us the paragraph. Give us the paragraph. Which para?
23, madam. Learned pen has does not really have it.
para 26,
24.
24 and 26. Para 24 says the opinion and order of tribunal or the order passed by the registering authority based upon the opinion of tribunals, as the case may be, can be silenced by way of writ proceeding. Thus, it would be incorrect to hold that the opinion of the foreigners tribunal or the consequence order passed by the registry authority would not operate as res judicata. Both the opinion of the tribunal and the order of registering authority result in determination of right status under the statutes and by an authority after contest on the merit, we should necessarily operate as bar to subsequent proceeding before the same authority for redetermination of the same issue. The court in so and so has held that. My lord, we may consider this para 24 also, 24 and 25. This will clarify some extent, my lord. Let us read it followingly, my lord. The opinion order of the tribunal or the order passed by the registrar authority, there are two authorities, based upon the opinion of the foreigners tribunal, as the case may be, can be silenced by way of writ proceedings. The opinion, my lord, the opinion of the tribunal, order passed by the registering authority, my lord, NRC registering authority, based upon the opinion of the foreigners tribunal. The registering authority's opinion, which is based upon the foreigners tribunal's opinion, that can be silenced at the writ proceeding, can be silenced by way of writ proceeding. Thus, it would be incorrect to hold that the opinion of the foreigners tribunal and or the consequence order passed by the registering authority would not operate as res judicata. That means both the opinion of the tribunal and the order of registering authority result in determination of right status under the statute and by an authority after a contest on merit, we should necessarily operate as a bar subsequent proceeding before the same authority for redetermination of the same issue of the question. So it is, my lord, from this reading, it is clear, my lord, if the foreigner tribunal pass an order, it will res judicata in foreigners tribunal. That is to say, and if it is by, my lord, registering authority, then it will go against registering authority. Res judicata lies on registering authority also. The same principle apply in both the authority. Thus, court in so and so has held that the principle of res judicata equally apply to quasi-judicial bodies. As it is quasi-judicial bodies, it will apply to quasi-judicial bodies also. Whenever a judicial or quasi-judicial tribunal gives a finding on law or fact, its findings cannot be impeached collaterally or in a second round and binding until reversed. It appeal or by way of writ proceeding. If it is not reversed by way of appeal or writ proceeding, it will be a binding. The characteristic attribute of judicial act or decision is that it binds, whether right or wrong. Thus, any error, either of fact or law, committed by such bodies cannot be controverted otherwise by way of appeal or writ, unless the erroneous determination relates to jurisdictional matter of the body. So this 24 is clear, my lord. 26 also, my lord. When we apply to general principle of res judicata, the contention of the appellant that the person concerned should be permitted to double dip and be entitled to second round of litigation before foreigners tribunal, notwithstanding the earlier opinion expressed by the foreigners tribunal, is far-fetched and completely unacceptable. The plea is fallacious and has no merit. There they play, my lord, in that case, they prayed for another litigation in the foreigners tribunal, which was set up under 2003. That was negated by the Honorable Apex Court. But in the present proceeding, what is the problem?
Yes, Mr. Das. In the first case,
Yes.
it was in the name of one Saleha Begum,
Yes,
wife of Muhammad Sanur Ali of Horiyahatoli Police Station, Nalbari.
Yes.
That was initiated in the year 2000. And during the police inquiry, you did not disclose anything. In your written statement before the tribunal in your first case, which was Saleha Begum, wife of Sunur Ali. In your written statement, you have just mentioned that you have submitted the photocopies of your father. You did not even mention the name of your father. Who is your daughter of whom, whatever, nothing. In the written statement, there was no affidavit. In the position before the tribunal, you said you are daughter of Qasim Ali, wife of Sunwar Ali. Your deposition was recorded on 4/7/2014. In the first case. And two 2009, there was a second inquiry against you. And your statement was also recorded by police. The second case relates to Muhammad Suleha Begum,
32.
because these things are important. Daughter of Qasim Ali, wife of
Tanur Kanwar and like this. Kamtesh Tanur, Kamtesh Kanwar.
Sound, not sound. Sound.
Sonwar Hussain.
Yes.
Earlier was Muhammad Saleha Begum, wife of Muhammad Sanur Ali. Second is Muhammad Saleha Begum, wife of Muhammad Sonwar Hussain. Now, in the earlier case, You have exhibited a photocopy of a voter list of 1965. And in the voter list of 2011, with your name. Now, how to identify Saleha Muhammad Saleha Begum, wife of Sunur Ali, is the same lady that is the wife of Sonwar Hussain. See, basically, in the deposition before the tribunal, your deposition before the tribunal in the first case, you have clearly mentioned that you are the wife of Sonwar Ali. Though you have adduced or you have placed a voter list of your vote, your name, but that was in the name of Sonwar Ali. The second case is Sonwar Hussain. What is your proof that you are the same lady? Have you gone through the records, Mr. Das? Have you gone through the records?
Oh, no, my lord, I do not.
Yes, Mr. Das, Mr. Kalita and Mr. Das. This is the present case.
I have gone through this.
তৎকালীন সালেহা বেগম, স্বামী মোহাম্মদ আনুর আলী, ওরফে সানোয়ার আলী, সাংসৰীয়াতলী থানা জিলা নলবাৰী অসম মই সবত্ৰে ধৰ্মত প্ৰতিজ্ঞা কৰি কওঁ যে উপৰোক্ত ঠিকনাই ঠাই ও জন্মসূত্ৰে ভাৰতীয় নাগৰিক এই কথা মোৰ জ্ঞান মতে সত্য মই ধৰ্মত প্ৰতিজ্ঞা কৰি কওঁ যে মোৰ স্বামী তনুৰ আলী ওৰফে ছানোৱাৰ আলী বুলিও জনাজাত এই কথা মোৰ জনাত সত্য মই ধৰ্মত প্ৰতিজ্ঞা কৰি কওঁ যে উক্ত মোকৰ্দমা মোৰ ওপৰত ষড়যন্ত্ৰ আৰু হাৰাশাস্তি দিয়াৰ বাবেহে ৰুজু কৰিছে এই কথা মোৰ জ্ঞানত সত্য মই ধৰ্মত প্ৰতিজ্ঞা কৰি কওঁ যে মোকৰ্দমাৰ উপৰিও মোৰ ওপৰত বিভাগীয় কৰ্তৃপক্ষই এপ্লিকেশ্যন নম্বৰ 54593/2006 গোচৰটো ৰুজু কৰিছিল আৰু উক্ত মোকৰ্দমাৰ সাক্ষীবাদী লৈ মোক ভাৰতীয় নাগৰিক হিচাপে যোৱা 8/9/14 ইংৰাজী তাৰিখে হুকুম কৰিছে এক্সিবিট 1 উক্ত মোকৰ্দমাৰ কপি ফটোকপি মই ধৰ্মত প্ৰতিজ্ঞা কৰি কওঁ যে মই বৰপেটা জিলাৰ ঢকুৱামাৰী গাঁৱত জন্মগ্ৰহণ কৰি সৰিয়াতলী গাঁৱৰ ছানুৰ আলী ওৰফে ছানোৱাৰ আলীৰ লগত বিয়া হৈ উক্ত গাঁৱতে বসবাস কৰি আছো এই কথা মোৰ জ্ঞানত সত্য মই ধৰ্মত প্ৰতিজ্ঞা কৰি কওঁ যে মই ভাৰতীয় নাগৰিক হওঁ আৰু প্ৰমাণ হিচাপে মোৰ দেউতা স্বৰ্গীয় কাছেম আলীয়ে 1965 চনত 48 নম্বৰ বিধানসভা সমষ্টিৰ সৰ্বভোগত ভোট দিয়াৰ প্ৰমাণ পত্ৰ এক্সিবিট 2 হিচাপে গাঁঠি দিয়া হ'ল এই কথা মোৰ জ্ঞানত সত্য মই ধৰ্মত প্ৰতিজ্ঞা কৰি কওঁ যে মই ভাৰতীয় নাগৰিক হওঁ আৰু প্ৰমাণ হিচাপে সৰিয়াতলীত বাল ভৱন হাইস্কুলত 1911 চনত ভোট দিয়াৰ স্বাক্ষৰিত নকল এক্সিবিট 3 হিচাপে গাঁঠি দিয়া হ'ল এই কথা মোৰ জ্ঞান মতে সত্য
Where is the link document to show that you are the daughter of Kashem Ali?
My lord, I beg to draw your attention to order of this court dated 25/4/23 and order dated 23/23. In these two orders, my lord, I was directed by the court to produce any document which can show that Saleha Begum is the daughter of Kasem Ali. Thereafter, I filed an affidavit, enclosing certain documents. And in those documents, I have that copy of that affidavit on the other side of the room. Here I have submitted one certificate issued by Circle Officer Dala Revenue Circle Mala. In this certificate, he has stated that Saleha Begum, daughter of Kasem Ali, mother Umesha Bibi, Ukwamari village under Dala Revenue Circle, District Assam, who is aged about 38 years, was a resident within the jurisdiction of the said village. And Srimati Saleha Begum got married to Sri Kanwar Ali, son of Sohrab Ali, and Saira Khatun, mother, who are resident of Horiatoli under Nalbari Revenue Circle of Nalbari District, Assam. So, I enclosed that document with my lord, as per order of this court.
Now that is one Abdul Kashem Ali. It's not Kashem Ali.
Abul Kasem Ali, this one.
Where did you say before the tribunal? What is the name of your father?
Kasem Ali.
These Muslim people, they call Ali Hussein.
You have mentioned the name of your father as what? You relied on a voter list of your father of Kashem Ali. Though it was not proved, it was a voter list of 1961. Now, how Kashem Ali has become Abdul Kashem Ali?
How they written this thing.
That is a difficulty, and these documents not proved before the tribunal. Anyway,
But the
now-
husband's name has been the same and the name of the village is also the same, my lord. So with all the probability, my lord.
where you have mentioned that you had a brother,
She has got a brother, my lord, Omar Ali.
in
And
your written statement before the tribunal,
I have not
have you
got
said
that one, my lord.
anything?
No, he has not given a statement as for husband, my lord. Umar Ali is her brother, my lord, and she was enlisted as voter with Omar Ali, saying their father's name is Captain Ali. In village Hukwamari village.
Village Bhukamari, one Abdul Kashem Ali might be there, or Abdul Kasem may be there. But you have mentioned your father as Kasim Ali. You have placed a document before the tribunal showing that Kashem Ali was the voter from Bhukamari near 1961. But Mr. Das, tell me one thing,
Yes, sir.
whether the Kasem Ali existed after 1961.
Mhm.
The second case is purely against one Muhammad Saleha Begum, wife of Sunwar Ali alias Sunbar Ali. Right?
Yes, sir.
Not with regard to wife of Sunur Ali of village.
Hussein, Lordship, Shinwar Hussein.
One is Sunwar Hussein. So how do you prove that?
My lord, I am a resident of village story authority.
There may be many persons in the village.
I have received notice from that tribunal in the same village with two different names of my husband.
That is why we are asking you, what
We
is
have
your
clarified
stand
in
before
our
the
affidavit, my
tribunal?
lord, that Sanwar Ali and Sanwar Hussain
Hmm.
is her husband.
No, wait. First of all, to be, it's a res judicata, you have to be able to show that you are the same person. Right? Where from you have proved that you are the same person? Yes, pass on the record. Yes, Mr. Kolita.
Lordship. Lordship, there is nothing on record to show that these two people are same. And secondly, this father's identity also, there are certain documents they have brought in subsequently.
No, those
That-
are not.
That again says a different person. And Gawura specifically says in the second case, Lordship, that she is the wife of Sanwar Hussain. Now, two different persons, Sanwar Hussain, Sanwar Ali. So the fact of the issue of res judicata is not at all necessitates here, Lordship. There is no necessity of going into that issue. Because principle of res judicata, to be applicable, there has to be the same parties. And they have not taken this, they could not prove that they are the same person. And like Learned Foreigners Tribunal also taken the view that these two are different persons.
My lord, in the notice which I had received from the tribunal, my lord, in that notice, my name was mentioned as Saleha Begum and wife of a Sanwar Hussain, my lord. But In the judgment, my lord, in the same case, the name of the husband has been shown as Sunwar Ali alias Sunawar Ali and not Sunwar Hussain, my lord. This thing, my lord, in case of Muslim
That's right.
person. And although
Those are
my,
no evidence, Lordship. Those are no evidence. Those are not material things to be
no,
looked
where
into.
from they got the name Sanwar Hussain in the notice, my lord. I know that my husband is Sanwar, so I received the notice.
The
although
Enquiry
it was
report
Hussain.
only, enquiry report only that is there. They say, boy, she herself disclosed that she is the wife of Sanwar Hussain. That was never brought into challenge.
Your only case is that this is your second case, and in the first case you have been considered to be an Indian. So the case is brought by residing. This is your case.
But they were very subtle law. And Lordship, as far as like putting the name in the notice and all that, those are subtle law, Lordship. Like our Honorable this High Court has already stated that those are no evidence, no proof. There.
These are parts of record.
High Court has settled to disable.
It
High
is
Court
not
को लगी
necessary in this case. This is the document issued by the court itself.
and that has been given judgment by the Honorable this Court.
Public. Kindly read, Mr. Das.
This cross-examination, right,
Hmm.
of Saleh Abdul. My father was a resident of village Hukwamari under police station Torbuk of district Borpeta. My father had three brothers, namely Mofez Ali, Intaz Ali, including my father. My father had no sister. I got married about 20 years ago. I casted my vote, but I was marked as D in the last year. I have three children, namely Muhammad Fanidul Islam, aged about 15 years, Muhammad Fajida Begum, aged about 15 years, Muhammad Shahnaz Ali, aged about 12 years. I shifted my place about 20 years ago after my marriage to the present place. Now I am permanently living in village Suryatuli. I was a voter at the place of my father. At village Bhukamari, my brothers, namely Usman Goni, aged about 60 to 65 years, and Umar Ali, aged about 60 years, Muhammad Ishaq Ali, aged about 57 years, Muhammad Iman Ali, aged about 46 years. I have three sisters, namely Muhammad Bhanu, aged about 58 years, Muhammad Khadija Begum, aged about 55 years, and Muhammad Tahira Begum, aged about 50 years. Milord, I have produced one voter list with Omar Ali, Milord.
So here she stated before the tribunal that she had cast vote the place where she used to reside earlier, that is Bhukwamari.
Yes.
Right. Where is that portal? Yes. Come back at 2. Record. What's on the record? Yes.
May it please the loss. My lord, seeking a loss of indulgence. With respect to item number 19, my lord. My lord, may it
Which may not
be taken
reach-
on some other day, my lord.
Don't worry.
Item number 10. There are two items already going on this part of the one.
Admission. We'll pass necessary order. Don't worry. Yes, Mr. Das.
Not
My lord,
Hmm.
in the name and the name of persons and the name of villages regarding shifting from one village to another, my lord. The guideline of the central government is that only the tribunal has to consider the probability as per material adduced, evidence adduced on record, whether that record shows the probability, whichever probability shows as per that decision has to be given.
Hmm.
So in my case, Your Lordship, Kanwar is the same, but title is somewhere it is Ali, somewhere it is Hussein. But name of the father and the name of the village is same, and this shows, my lord, that probably Kanwar, Hussein and Sanwar Ali is the same person, and he is the husband of the petitioner. Now, this court has held this one, that tribunal has to give the opinion on the basis of preponderance of probability, my lord. Because this type of enumeration will always appear, my lord. So we have to, what the tribunal has to see, what is probable on the basis of the materials on record. In this case, I am in very seriously. I received the notice. In the first case, I appeared, I adduced evidence, and I was declared to be not a foreigner. Subsequently, I received another notice in the same village with the same father's name and husband's name, my lord.
Okay. Anything else you like to add?
Hmm?
Anything else you like to add?
No.
Mr. Sharma? Yes, Lordship. And Mr. Das? You have heard submissions, but which we like to point out is this. In the first case, both the cases was during when the IMDT Act was in force. The reference was made during that point of time. In the first case, it is Saleha Begum, wife of Muhammad Samnur Ali of village Puriotoli, Nalbari,
Yes.
where the tribunal passed the order in favor of the
Proceed.
Prosidi Musammat Saleha Begum. Saleha Begum. But the reference was against Saleha Begum. SCLEHA, not SA.
Yes.
But the tribunal passed the order on in favor of some Musammat Saleha Begum, wife of Muhammad Sanur Ali of Puriotoli. The second reference, the investigation, everything was with regard to one
Kuleha.
Suleha Begum. Suleha Begum. Not Saleha or Saleha. This
Within
time
the
it is,
government, it is Saleha.
the record is before us. That is why you are mentioning. Suleha Begum, wife of Sanwar Hussain, daughter of Qasim Ali.
My lord, in the notice, my lord, in that second case, my name has been mentioned as Saleha Devi. This is
The
the,
police reference, the border, Superintendent Police border referred the matter. Investigation was against Suleha Begum. Suleha Begum, wife of Samnur Hussain, Sonwar Hussain,
yes.
daughter of late Qasim Ali.
Residents of Bangladesh was also in both the cases different law. In inquiry report, resident of Bangladesh,
The villages
in
of
both
Bangladesh,
the
they have
both the
different.
cases are different law.
Hello. এই মানুহজনে But Mr. Decidas Council hearing for the petition. Mr. A. Kalita attended. PN 5. Also heard Mr. H. K. Hazarika, Government Advocates for this. Yes, Mr. Hussain.
May I please, Your Lordship? My lord, I have gone through the records. My lord, the WS, which is submitted by the OP, is a little bit detailed, Lordship. And the evidence also adduced by the DW and DW2 are also in details, and those are explained in the evidence produced by the exhibit A to D, Lordship.
Mr. Hussain, first of all, you know, you may not make any submission, particularly the proceeding beyond her written statement or reply, right? Now, from the record, please make your submission with regard to the written reply or written submission of the proceeding. On the records, make your submission regarding the record is before us. Okay, record is not with you.
Lordship, may kindly see, I have noted down DW1 and DW2 here from the record, Lordship. DW1, Lordship, DW1 is at test 3 of the record, Lordship. I was born and brought up at village Porua, PS Tezpur, Sunitpur. My father's name is late Ali Hussain, alias Hussain. He was an original resident of Porua under Tezpur PS. His name appeared in the voter list of 1966 from village Porwa under 77 Tezpur LAC at serial number so-and-so, house number so-and-so. Exhibit A is the copy of the voter list. My father shifted to village Bhitor Suti under Tezpur PS. My father died about 10 years ago at village Bhitor Suti. My elder brother Abdul Rashid later on shifted to village Gorshinga Bihiagao under Tezpur PS. He is still residing there. His name appeared in the voter list of 1993 at Bhitor Suti Gao under 73 Tezpur LAC. Serial number, house number so and so. Exhibit B is the voter list of 1993. Exhibit C is the voter ID card bearing number so and so issued in the name of father. I got married with Abul Kalam of Bhuskwa Chapuri. I casted vote at Bhuskwa Chapuri in the year 1997 under 73 Tezpur LAC by serial number so and so, house number so and so. Exhibit so and so is the voter list. Subsequently, we shifted to village Kocharipam, PS Tezpur, and I am residing there with my husband now. I am a citizen of India by birth and not a foreigner. Cross. I have not submitted birth certificate. I have not submitted any documents prior to 1966. It is not a fact that Exhibit B is belong to Abdul Rashid because father's name is written as Ali only. It is not a fact that I have adduced false evidence. Shifting marriage, everything is mentioned here, Lordship. Then Lordship may kindly see DW2 at page 5-6 of the record, Lordship. OP Sulema Khatun is my younger sister. She was born at village Porwa under Tezpur PS. My father, late Ali Hussain, was an original resident of Porwa. His name appeared in the voter list of 1966. Exhibit A. Subsequently, my father shifted to Bhitor Suti Gao and father died there later on. My name appeared in the voter list of 1993 at Bhitor Suti Gao. Exhibit B is the voter list. Subsequently, I shifted to Gorshinga Bihiagao. I am still residing there. I am holder of voter ID card. Exhibit C is the voter ID card. My sister Sulema Khatun was given marriage to Abul Kalam of village Bhuskwa Sapuri. OP's name appeared in the voter list of 1997 of village Bhuskwa Sapuri. Exhibit D is the voter list. Later on, OP and husband shifted to village Kacharigao PS Tezpur. They are still residing there. She is a citizen of India by birth. I have not submitted birth certificate of sister. It is not a fact that there is no legal validity of Exhibit C. My lord, the statement made in the evidence and also in the WS Lordship, everything based on record, Lordship, and records are, Lordship may kindly find the voter list of 1966 at page 21 of the record, Lordship. And the other shifting is also mentioned in the WS, and the voter list of shifted residents is also exhibited as Exhibit B and D, Lordship. Everything is on record, Lordship. They have filed WS, they have adduced evidence of DW 1 and 2. And regarding the documents they did not produce, as my learned friend submitted in between 66-93, these were not a question before the learned tribunal, Lordship. These are not a question. And Lordship, the brother, elder brother adduced evidence as DW2. It comes under section 50 and 51 of the evidence, special knowledge regarding the fact, Lordship. And these things were considered by the learned tribunal while passing the order declaring the respondent as Indian citizen, Lordship.
So according to you, prosody and prosodity's projected brother has had a special knowledge of shifting from one village to another,
Yes,
village Porua to village Hitorkuti. So, as she and her projected brother have deposed before the tribunal, so their statements should be considered as the evidence and the link to prove
yes, Lordship. Supreme Court in Sirajul Haq, Lordship. Lordship is aware, Sirajul Haq, decided by the Honorable Supreme Court. It is also mentioned in that order that shifting cannot be a ground to reject the documents. It is also there, Lordship.
that's it.
So
Shifting
one
cannot
person,
be a ground.
person-
Cannot be a ground, definitely not.
yes, Lordship, of disbelieving documents, Lordship.
Question of disbelieving is not involved here. Question of is that the prosody was required to prove her linkage with her father Ali Hussein of village Porua. As per the written statement,
Page 21, Lordship.
the father of the prosody, Ali Hussein, after the expiry of father of the prosody, her elder brother, Abdul Rashid, moved from village Hitorsuti to Gorisinga Bihia Gaon. Gorhinga Bihia Gaon.
Yes,
That means at certain point of time, Prosidy's father, Prosidy's brother all shifted from village Porua to Vitorhuti. When? When? That has not been mentioned.
mentioned, yes.
In the written statement, the Prosody said that after the death of her father, Ali Hussein, her brother shifted from Vitorhuti village to Gorhinga Bihia Gaon. That is also there. In her evidence before the tribunal, she deposed that her father expired 10 years back.
10 years.
So, considering the deposition of the year 2016, July, we can say that 10 years means 2006. So, up to 2005, father of the prosody, Ali Hussein, was alive, and he along with her son, Abdul Rashid, were there at village Hitorkuti. There is no document before the tribunal, or there is no mention by the prosody before the tribunal as to when her father along with elder brother shifted from village Porua to Vitor Huti. At least we know from the statement of the President that her father was alive up to 2005. So, from the voter list, village Porua relating to the projected father of the petitioner Ali Hussein of 1966, there is no other document of Vitor Huti except the voter list of 1993 reflecting the name of her projected brother Abdul Rashid, and son of Ali. Right?
No.
So these things have to be proved by the proceeding as required under Section 9. You cannot pick up a document from one village because somebody is son of Ali. If Ali Hussein was alive up to 2005, then from after 1966 to 2005, there has to be some document. 1993 voter list of Abdul Rashid reflects clearly that he was 30 years old. That means if he was in 1993, he was 30 years. His birth year was sometimes in 63. So, '63 plus 21, 1984. But the projected brothers voter list is only of 1993. Had this voter list together with Ali Hussein could have been different. Or any continuous voter list of Ali Hussein from 66 of village Porua or thereafter 2-3 elections from Porua and then something from village Vitor Huti would have given a different picture, right? But there is no voter list either of Porua or of Vitor Huti, of the elder brother of the petitioner, prior to 1993, nor of this Ali Hussein, son of, what is his name?
Abdul Rashid.
Laljan. And that is why in the Sarvananda Sonowal, the Honorable Apex Court have categorically mentioned at para 26 the duty of the proceedee to mention, to identify herself or himself, particularly the proceedee, what is required.
Lordship
That
being,
is the reason why, because Section 9 is the Foreigners Act is such entire burden. From these documents, we could not find anything how the tribunal on what basis come to the finding that the proceedee proceedee's father was there up to 1971. Where from? There is no document to show, no statement was shown.
Lordship, to that effect,
Hmm.
my humble submission is that Lordship is aware
Hmm.
that proof of such cases is not required to be proved strictly.
Hmm.
It is just preponderance of probability, Lordship.
Hmm.
And Lordship, the learned tribunal took judicial.
The preponderance of probability up to which level?
There is
That probability, right?
yes, Lordship.
What is probability?
Lordship, they adduced evidence, they submitted WS stating everything, every details, Lordship. And thereafter, they exhibited some documents, Lordship. And the documents are referred in the WS and evidence, Lordship.
Hmm.
So Lordship, on that
There may be a
basis,
possibility,
the
there may be a possibility. Probability you're talking about. When this probability is there is also a possibility or probability that Ali Hussein, though came to India and his name figured in 1966 in the voter list, thereafter he might have left India. We do not know, probability. And that is why his name did not figure in any of the voter list, either from village Purua or from Vitorhuti till he was alive, because he was not there in India.
that presumption may be there, Lordship.
Probability.
Lordship.
See, when the
Yes,
probability has to
Yes.
come from certain thing,
Yes,
then this Abdul Rashid might have entered India sometimes in 1990, and that's why his name figured in the 1993.
Lordship, that
Probability.
probably may
We do
also
not
be
know.
there, Lordship. Therefore, Lordship, my humble submission is that earlier honorable coordinate bench of this honorable court also used to answer the such question. They call for the voter list from the issuing authority, Lordship, from the concerned authority. May I
See.
pray that after 66, the relevant record with regard to the voter list with regard to this family may be called, and learned friend is there. They may
See, basically, here we are dealing with this writ petition has been filed against the order of the tribunal to show that the tribunal, giving weightage on the irrelevant consideration, came to the conclusion that the proceeding is an Indian or as not a foreign. Right? To that extent, the state has given these materials before the tribe, before this court. And in support of the case of the petitioner, or sorry, of the proceeding, you are relying on the documents and the statements made by them to that extent only.
that is I can rely on the to that extent only. In addition, my submission is that, Lordship,
Mm.
the record from 19 after 66
Mm.
till date
Mm.
with regard to this family may be
Mm.
called, Lordship,
Why
voter
actually,
list.
it will be the tribunal, it is the duty tribunal to decide. Why was the requirement of us to calling on while taking a decision under certiorari right? We cannot say anything at this stage. Only we can determine whether the order of the tribunal is good or bad.
Lordship, to answer the question of this probability, Lordship, earlier honorable coordinate bench also passed so
That
many
is the
orders.
reason- That is the reason whether we are empowered to do so. Are we executing, are we looking after the certiorari of mandamus or any other thing, or accepting certiorari, or we are exercising our rights under certiorari?
And Lordship, with regard to the para 26 of Sarvananda Sonowal, Lordship,
Mm.
regarding details, she has mentioned everything.
Mhm.
She or DW1 or DW2, and only they could not mention the date of birth, which is also Lordship also knows that which is not possible because they probably they were born prior to 1970 or 71, and they are illiterate people. They may not have those documents proof regarding birth, Lordship. So these things may not be there. This is the practical situation, Lordship. Other informations are available. When they, where they were born, in which family they were born, the jurisdiction, where they shifted, where they married, everything mentioned, Lordship. Every details are there.
Anything else?
Lordship, regarding uh, uh, regarding the findings of coordinate court, Lordship, the courts are bound by judicial discipline and finding of higher courts or coordinate bench must be considered. Regarding this issue, Lordship, I am referring one judgment,
Hmm.
AIR 2005, AIR 2005 SC 91,
SC 91.
921.
Hmm.
Lordship.
So which is the coordinate judgment? Coordinate bench judgment?
Coordinate bench judgment, Lordship. Present, I do not have that judgment.
So why you are placing this?
I-
Why?
Lordship, in my knowledge, Lordship, there are so many judgment orders, Lordship, of this honorable court. I can produce those orders, Lordship.
Let's see. Anything else you like to reply? Anything else you like to reply?
Lordship, this one. Obliged.
Mr. Pine?
My lord, if my lord can realize that, my lord, that I have already produced 3 judgment of this honorable court, whereby it is said, my lord, that the oral evidence of the, my lord, DW2 cannot be accepted in that form. So it will cover. My lord, another aspect, my lord, I have submitted already that, my lord, if we go to WS, my lord, we may see the statements of WS. Why I'm saying that, my lord? To identify a person, to know his, my lord, details about the person, what she has given. She has given that OP para 3, my lord. OP is a citizen of India by birth. She was born and brought up on Indian soil, that is at village Porua, Moja, Halsberg, so-and-so, district so-and-so. Is it enough? She was born on at village so-and-so. That much only. She has not given year of birth. I'm not saying date of birth. At least year of birth, probable date of birth, year of birth that I was born during this period, during 1960s, 65, during 65, 66, at least some probable dates. Where from the tribunal got that she was born in 1963 or she was born in 1971? Did she ever stated somewhere, my lord, she was born in 1971? She has not stated anywhere, but tribunal got that she was born in 71. Tribunal has given in tribunal's opinion, they have said that she was born in 71.
No, because she said 40 years.
40 years, she
So that's
calculated.
how,
At least that statement should be given by by herself, that as I am 45 years of age today, my date of birth is so and so. That should have been given in WS, either in WS or in evidence. That is not explained. Without giving any explanation, how can she presume that? That is presumption. The tribunal cannot presume that, my lord. With regard to presumption, my lord, presumption of, in such cases, my lord, one judgment of Honorable Apex Court I would like to point out, my lord. That is 1974, 3 SCC 469. 1974, 3 SCC 469.
Hmm.
Masood Khan. In that case, the Honorable Apex Court in 3 judge bench, my lord. It was Masood Khan versus State of UP. And from first para itself, it will be clear. Para 1 and 2, the details, my lord. In that case, Masood Khan praised for his release on the ground that he, an Indian citizen, has been illegally arrested and confined in jail under the paragraph 3 of the Foreigners Internment Order 1962. He had come to India from Pakistan on the basis of Pakistani passport dated 13/7/1954 and Indian visa dated 9/4/56. Have you also got it? In that case, my lord, he came from Pakistan and he was detained under this Foreigners Internment Order 1962. He challenged that order before the Honorable Apex Court, my lord. There, in reply, he said, in reply affidavit filed on behalf of the respondent, that is the state, that one Masood Khan, son of Jahul Khan, was enrolled as police constable on 16/9/47. He was enrolled as police constable in 1964 or 47 in India, and he was discharged from service on 25/1949. The Lordship will get it in the first para itself. It is fairly clear that the information culled from the English order book of 1/10/1947 to 27/12/51 refers to the petitioner. It is true. While, therefore, it is established that petitioner did not go to Pakistan in 1948. 1948. It cannot be said that it has been established that the petitioner was in Pakistan only in 1951. When he went to Pakistan is a matter of, my lord, when he went to Pakistan is a matter of peculiarly within his knowledge, and he has produced no evidence in support of the statement. Considering the frequent change of ground which the petitioner has resorted to, a mere statement from him cannot be accepted as true. It has to be seen, because nor can we accept his contention that it is for the respondent to establish that he did not go to Pakistan in 1951, but he went on some other day. My lord, his claim was that he did not go to Pakistan in 1951. In between this period, 1947 to 51. So that is especially within the knowledge of the petitioner. It should be pleaded by him. And if he is not pleaded, he doesn't plead that, my lord, it cannot be presumed. Later part also, in the next para 2, my lord, we are not to assume, my lord, this para 2, assumption. We are not to prepare to assume that the petitioner should be deemed to have been present in India on 26/1/1950, as was urged on behalf of the petitioner. Well, if the petitioner claims, the proceeding claims that I am in India, I was in India on so and so, that assumption cannot be drawn by the tribunal or the court, as urged on behalf of the petitioner. There is no room for any such presumption under Section 9 of the Foreigners Act. Whenever a question arises whether a person is or is not a foreigner, the onus of proving that he is not a foreigner lies upon him. That presumption is not there under Section 9. That first I want to show. There is no presumption of Indian, that petitioner is or proceed is an Indian under Section 9. The presumption cannot be taken by any court that he is a citizen. It is the burden of the proceeding to absolutely prove that he is a citizen. So presumption is absolutely on them. That I want to point out, my lord, from this judgment, it is clear that under section there is no presumption on the part of the tribunal cannot presume that he is a citizen. As because it is the government who has asked for an opinion that whether the person is a citizen or not. Because the question has already arisen that whether he is a citizen or not. So, as presumption is not there, the tribunal cannot take presumption that he was an Indian, and on that view, there should be a reverse, my lord, the evidence that he is to show that he is a foreigner. It is their duty to show, that he is an Indian by birth or by mother descendant. Now, where is the evidence? There is no evidence, only the oral evidence of the DW2. And even we accept the evidence of DW2 also, my lord. That what he has stated, all are vague. My lord, the tribunal has presumed that he was born in 1971. That is wrong. That presumption he cannot draw. Secondly, in page 11, my lord, the OPW2, here the OPDW1 has deposed in the examination in chief that she was born and brought up at village Parwa. That is the only evidence, madam. DW2, Abdul Rashid, younger brother of the OP, has deposed. In fact, if he is the younger brother, then his evidence may not have any value. Because he was born later on. But this has been contradicted. In fact, this is not younger brother. This should be elder brother, madam. This is because from the evidence it is seen that he is elder than the petitioner, the proceeding, the Abdul Rashid. The OP has deposed that OP Sulema Khatun was born in village Parwa. Stated that village, she was born in Parwa. When she was born, that is not stated. That is a vague statement. In the cross-section, OPDW2 has deposed that they have not submitted the birth certificate. They have not submitted the birth certificate. Why they could not say the melody? Both the proceeding and the DW2 could not say the exact dates or years because they are not belonging to same family. They are, in fact, I have doubt, my lord. It may not be record, but I have doubt the petitioner, the proceeding knows even her father. Whether she was born in that place, whether she knows the parents or not. Probably she don't know. She doesn't know anything about the entire family. She pick up the documents of 1966 and the documents of 1993, and on the basis of that only she is saying everything. She has no personal knowledge otherwise. So she could not say anything beyond those documents which were picked up by her. So whatever is stated, only on the basis of those two documents, 1966 voter list and 1993 voter list. She could not say anything in between period, madam. What she has stated, she has not stated, madam. Your lordship may kindly see in WS. The father's name is so-and-so, second para 4. The father name is Ali Hussain. That is in as per the record of 1966 voter list. Ali Hussain originally resided at village Parwa. His name appeared in the electoral roll 1966 from the above named village, and by so-and-so. Father shifted to Vitor Suti, Boripara. And when shifted, that is not mentioned. Vitor Suti, because the 1993 voter list of Vitor Suti village. So she said father shifted to that village, but she has not mentioned when it shifted. In between from 1966 to 1993. Name of the elder brother is named Muhammad Abdul Rashid, appeared in the voter list Abdul Rashid name is appearing in the voter list 93. So she have started that much only. And after the death of father of the elder brother of the opposite Abdul Rashid, along with family members, again shifted to resident of village Garsinga Hanga. Because in that place, this Garsinga village, the brother presently residing along with a mother voter ID. So she has deposed whatever only they are in the record given to her, not on her personal knowledge. These documents were given to her. And on that basis, she has stated it. She has no personal knowledge at all. That's why she could not say when did father died. Only when the parents shifted. What happened to parents? This nothing, no statement is there. In fact, she has intentionally not stated when did she got married. I'll say intentionally, because if she says she got married in prior to 1993, there may be some difference. If she says she got married in after 93, why her name is not in the voter list of 1993 along with the brother? That question arises. So she intentionally avoided that. This is the process of avoiding the real fact. They try to avoid all those real facts. Had she been fair, she could have said, I was married prior to 93, or I got married in 1990, or I got married in 1995. Why it is not stated? Because of this complication, so that the complication may not arise later. She will take any view. That's why Honorable Apex Court in that judgment said, my lord, they can sense the view, they can sense the position each and every moment. In WS, you will say something. In evidence, you will say something. Now we can examine the W evidence, what she has studied in her evidence. Same thing, I was born and brought up at village Porua. No year, nothing. And my father's name is Ali Hussein. He was originally resident of Porua village. His name appeared in the voter list of 1966. Whether his name was appearing in 1971, that will not state, because the 71 voter list is not there. Whether he casted vote in 1971, what happened in 83, 84, whether he casted, those will not come here, because those were not given to her, those documents. His name appeared in the voter list of 1996 from Porua village. That is, my father shifted to Hitor Suti under so and so, no year, no probable years mentioned. My father died about 10 years ago at village Hitor Suti. This was not stated in the WS. When it was stated in, my lord, intentionally this was not stated in the WS. When it was stated in the evidence, it caused damage the entire case. Now it damaged the entire case. Because that means if father died just before 10 years from 2016, where was the father from 1966 to 2006? Why his name is not nowhere in any voter list along with the petitioner, along with the proceeding, or with the projected brother? This question comes normally. That's why these were not stated prior to that. My elder brother Abdul Rashid later on shifted to village Garsinga, that is as given to her. Bhaigaon under so and so. He is still residing there. His name appeared in the voter list of so and so, 1993, at Patishuti Gaon, that same village. So, Exhibit B is the voter list of 1993. Whatever given to her. Exhibit C is the voter ID card bearing so and so, my in the name of brother. I got married with Abdul Kalam of Bhuskua Sapori, but no year, no probable period is given. These are intentionally, these will be left out. I got married with Abdul Kalim of Hitor Suti Sapori, Bhuskua Sapori. I casted vote in the year 1997 under so and so LSC. Exhibit D is the copy of voter list. Subsequently, we shifted to village Sapori Park, so and so, so and so. I have not submitted in cross part, she said, I have not submitted any birth certificate. I have not submitted any documents prior to 1966. There is no documents of prior to 66, even after 66, from 66 to 93. It is not a fact that Exhibit B is not belong to Abdul Rashid because the father name is written as Ali. Now, there is just Ali Hussein in 1966. That part is also ignored by the tribunal. In 1966, the projected father was Ali Hussein. 1993, it is Ali. Ali Hussein and Ali is a huge difference. This was not considered by the tribunal. Only it is not affected. I have adduced false evidence. So from this, it is clearly seen, my lord. It can be clearly seen that these are all vague statements. There is no specific statement. What is the specific knowledge? If we see the specific knowledge of the DW2, what he has stated. If we see, my lord, DW2's statement, OP Sulema Khatun is my younger sister. She was born at village Porwa under Tezpur PS. That only. Here also, he has not stated when did the sister born. The father, late Ali Hussein, was originally resident of village Porwa. Same, whatever is given there. His name is appeared in the voter list of 1966. Subsequently, my father shifted to so-and-so village. Father died there later on. He has not given a specific time period because either he doesn't know or he intentionally did not give the year. Because the sister did not give the probable years of death. But later on, at the time of evidence, he has given. My name appeared in the voter list of 1993 at so-and-so village. Subsequently, I shifted to Garsinga village. I'm still residing there. I'm holding a voter ID card. Exhibit C is the voter ID. My sister Sulema Khatun was given marriage to Abdul Kalam. Here also, he doesn't mention the probable year of marriage, my lord. Even probable year of marriage. OB name was appeared in the voter list of 1997 of Huskwa Sapuri. Exhibit D is the voter list of Exhibit D is the voter list. Later on, OP's husband shifted to some other village. That is done. I have not submitted birth certificate of my sister. It's not a fact that there is no legal validity to Exhibit C. That must be. So what is the specific knowledge? To get a specific knowledge, if my learned can argue, even though the section 50 of the Evidence Act may not be applicable for the foreigners' cases because of the judgments of the Honorable Court, as well as the section 9 of the Foreigners Order Act, even though it is not applicable. If we assume that for the time being it is applicable to section 9, it says specific knowledge, special knowledge. What are the special knowledge? When did the proceedee was born? That is not stated. That is the first point to be stated by the DW2. He should know the special knowledge. He should have the special knowledge that my sister was born on exactly this day, at this village, at this time. If he has no knowledge of that particular point, with the special knowledge. Secondly, he has stated my brother got married with so and so. When did she got married? That is not stated. If it is these knowledge are not with him, how can he say on my special knowledge it can be accepted that? Secondly, what we want. The petition was born in India that is either prior to 71 or after 71. If after 71 also, when that has to be established. Secondly, if she want to establish herself citizenship by way of the parents who were there prior to 1971, he has to give a clear evidence that the father or parents of the proceedee was there in 1961 or 1966, 71. These are the documents or these are the evidence. And being she was born to them on this particular date at so-and-so village, and she went to school or she did not go to school. She got married to so-and-so person on this particular day, and I, being the brother, I was present there, and I had the special knowledge because I was the age of such age that I could understand everything. I could have the special knowledge of those things. So I'm being deposing all these things. This has to be. My lord, if the petitioner was, the proceeding was 63 years, was born in 1963, though he has not stated, the tribunal has presumed that he was born in the DW2 was born in 1963. As because he was 30 years in 1993. At that 10 years, then proceeding, the tribunal also presumed that proceeding was born in 1963. So in between, from proceeding was born in 1971. From 63 to 71, if there are any brother and sister of the, whether there is any brother and sister of the proceeding or the DW2, those were not stated. Those are the special knowledge, madam. Each and every case, yes. Special knowledge must come from direct evidence, madam. You should know directly each and everything. It cannot be by way of hearing from each one another. But in the present case, but foreigners tribunals, my lord, it is clearly settled by this honorable court that this oral evidence will not come to help the proceeding, because it's a different kind of proceeding. It's not a proceeding, normal proceeding like any other case in the civil court. And in section 9 itself of the foreigners tribunal, foreigners itself has clearly said that burden of proof lies upon the proceeding, notwithstanding anything contained in the Evidence Act. So Evidence Act will not directly come into play in case of foreigners. Disclose this wording, my lord, notwithstanding anything contained in the Evidence Act of 1882 lie upon such person. That is proceeding. So the Evidence Act, the provisions of Evidence Act may not be applicable in all cases, except in the burden of proof. Burden of proof, except may not lie, because this section has said and this honorable court numbers of judgments, as I have already pointed out, my lord, it is clearly settled. Now, the tribunal has given some perverse findings that at the time of, in the third para of page 11, my lord, says at that time, parents of OP were present at village Porua. Where from he got it, my lord? No evidence has shown that during 1971, parents of the petitioner proceeding were there in Porua village. In view of that, I have found that OP was born at Porua after 1966. Where from she got it? The tribunal got it. There is no evidence to that effect that the proceeding was born after 1966 at Porua village. Her parents were present as citizen of India. This is also not based on record. So this entire findings, my lord, of para 3 of page 11, as per voter list of 1983, Abdul Rashid DW2 he was 30 years old in 1993. And that is on the basis of the record of the 1993 voter list. It appeared that he was born in 1963. From the 1993 voter list. OP was born after 1963. That is without any record. because the OPDW1 has stated that she was 45 years old. Now she was 45 years old. That means in 2016, she was 45 years. 5 years. So on calculation, it is said that if that being so, OP was born in 1971. At that time, parents of OP were present at Village Purva. This point is nowhere there in evidence, madam. In view of above, I found that OP was born in Purva after 66. This finding also not based on record. So without any evidence, the tribunal has passed this order and it has to go by. We are not saying that, my lord. Hmm.
Anything else you'd like to add?
My lord, may kindly just note down through judgment of this honorable court, my lord.
Hmm.
That is 2019 5 GLR 471. Same is reported in 2019 1 GLT 784, man.
2019 5 till year
471, man.
equivalent to
471. Relevant, it is same as 2019 1 GLT 784.
what else?
My lord, another is, my lord, that 2370/2023 WPC.
Yes.
2370/2023 Aziz Mia. That is disposed upon 9/6 to 2023, madam.
What is the proposition
The
here?
proposition there is, my lord, that if the petitioner proceeding wants, my lord, want to link himself or herself to a voter list of 1966 or 71, that I am the son or daughter of that person, that has to be established by bringing proper evidence, and without that, so that, my lord, that person is not other than my parents, that evidence must be there. Those persons are not other person, and those are my parents. That has to be established. Mere claiming, saying that in this 1966 my parents were there, that will not do. Para 14 of the first judgment, my lord, 2019 5 GLR 471. In fact, from para 11 onwards, it is relevant. 10 onwards, it is relevant. But we may rely on the, my lord, from para 10, section 9 of the Foreigners Act has been described, that, my lord, explained. From a reading of section 9, may I read the para 10? This is 2019 5 GLR 471. This is very clear, my lord. But from here it is clear. The provision of Indian Evidence Act may not apply in the Foreigners Act. Foreigners cases is strictly mine. But
Yes, kindly read.
para 10 onwards, madam. I'm reading. From reading of section 9, it is apparent that the onus of proving that the proceedee is not a foreigner or is not a foreigner of such particular class or description, as the case may be, shall lie upon such person, notwithstanding anything contained in the Evidence Act. In other words, the burden of proof the proceedee is not a foreigner would lie upon the proceedee himself or herself. In a proceeding under Foreigners Act 1946, in order to discharge such burden, if the proceeding relies upon a particular given person whose name appears either in voter list of 1966 or 70, or whose name appears in a particular land documents pertaining to the said period, or relies upon any other acceptable and admissible document which establishes the existence of such person within the territory of India during the relevant period of time prior to 1925 to 1971. The discharge of burden of proof as required under Section 9 of the Foreigners Act 1946 would be that proceeding concerned would have to prove his lineage to the particular person whose name appears in the aforesaid documents pertaining to period prior to 25 to 1971. Here in case matter petition, proceedee has brought 1966 documents. It has to be proved by him, by the proceedee, that lineage of the particular person whose name appears, prove that the proceeding concerned would have to prove that lineage to the particular person. He has to prove to lineage to that particular person. That is Ali Hussein, who is there in 1966. Although Section 9 of the Foreigners Act 1946 provides that onus of proving that proceedee is not a foreigner would lie upon such person, notwithstanding anything contained in the Indian Evidence Act 1872. But in order to understand the concept of burden of proof, we may still rely upon the concept of burden of proof as provided under Section 101 of the Evidence Act of 1872. Even though matter 101 will not come to play in our case, but for understanding, this Honorable Court has accepted it. Let us go to the 101 concept of concept. 101 of the Evidence Act says, whoever desires any court to give judgment as to any legal right or liability depends on the existence of fact, which he asserts must prove that those facts exist. If he claims that my parents were there in 1966 and being daughter, I am also a citizen, that fact has to be established by her or by herself. None other than the proceedee who has praying for that before the Honorable Tribunal. The concept of burden of proof as provided under Section 101 of the Evidence Act is that whoever desires, that is, I have read out, para 13. In the case in hand under Section 9 of the Foreigners Act 1946, the existence of fact which should be required to prove by the proceedee is that concerned person whose name appears in any of the aforementioned public documents, that in present case 1966 voter list, or the documents relied upon by the proceedee alone is the lineage of the proceedee. It has to be established that the proceedee alone is the lineage of the proceedee. As a corollary, any evidence being laid in a discharge of such burden of proof, we should indicate the lineage of the proceedee to a person merely having the same or similar name as that of person appearing in the public documents relied upon, in our view, would not be sufficient discharge of burden of proof to establish the existence of the fact that the person named in the referred public document constitute the lineage of the proceeding. It may be a similar person, similar name, my lord. So that's why para 15 it says, my lord, in order to discharge the complete burden of proof, the nature of purport of the evidence must be such that lineage is established not only with respect to the person whose name appeared in the public document relied upon, but at the same time rules out the possibility of it being linked to any other person having a same or similar name. This has to be done. So para 15 has to be complied with. Where is the compilation of the completion? The para 15 is not complied by the proceeding. And this is what exactly, my lord, in the tribunal they has to do. They needs to be.
Okay.
Then another case also same proposition, my lord. Same. Aziz Mia.
Aziz Mia.
Yes, ma'am. Para 14 it is there. Same proposition. Only one line, my lord, in para 14. That will be. We are considered to observe that a mere claim by suspected person by referring a voter list claiming a person therein to be his father is not a conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also further requirement to prove that the person who is reflected in the voter list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials or materials acceptable in law. The claim will not do much. That has to be substantiated with materials. Whereas the materials in the present case to show that Ali Hussein of 1966 is the father of the proceeding. In absence of those things, my lord, the tribunal should not have given this opinion. That's all.
Which para you said? Para?
Para 14, my lord. In fact, the same thing has been explained details in earlier judgment, my lord.
Or Mr. Depa, Extended Counsel from Department for Data Protection. Mr. Emma, London Counsel. London Amicus for the sole response. Reports of the case number 7, the room of chiefs was called for artillery. Ordered.
My lord, whoever like to give, you give tomorrow. Lots. All right.
Yes, ACB matter.
May it please the courts, my lord.
Yes, tell us what is the illegality.
Let's, in the instant proceedings, the short question before this honorable court is whether there has been compliance of the statutory provisions of the Electricity Act along with the AERC conditions, my lord. Now, the first illegality, there is a list of illegalities that have been committed by the respondents, my lord. Now, I'll walk your lordships through each one of them, one after another. The first illegality, my lords, is that our
Your
contention.
ground for challenging this.
Yes, Flores. The ground number one is that we claim that in the first instance, no notice was issued to the petitioner before disconnection of the electricity
Just
connection.
let us know what is the finding of the.
Yes, Flores. We have extracted the relevant portions that we seek to impugn in this writ appeal in our written submission. The same must be on record, your lordships.
Yes,
Your lordship, at page number 5. Here, whereas the contention of the respondents is recorded, the respondents, so and so, I'd like to read out the provision, my lord. A, the respondents in para number 5 of their affidavit in opposition have stated that, so and so, it is pertinent to mention herein that the temporary connection of the petitioner premises was done as per 8.2.1 of the AERC 2017, wherein it clearly stated that 15 days notice is to be given before temporary disconnection. In the instant case, the notices issued to the petitioner were duly served as the electricity bill issued itself contained the notice under section 56, subsection 1 of the Indian Electricity Act 2003. Therefore, the 15 days as per 8.2.1 of the AERC 2017 was duly complied. The first contention before the Honorable Single Judge was that no notice was issued. They said that notice was included in the bill itself, therefore it was issued. Now, I'd like to take your lordship to the finding of the learned single judge. Let's once.
Page number 6,
Yes, my lord. Page number 6 of the same.
continuous page number 127 for thought.
yes.
We have extracted the provision from the AERC, my lord, 8.2, temporary disconnection. It is,
Case number 6.
yes, my lord, page number 6 of the written submission.
Then the finding.
My lord, I'd like to just read it out, my lord, so that we have a clear understanding of the provision itself. 8.2, temporary disconnection. The supply may be disconnected temporarily in following cases. 8.2.1, disconnection due to non-payment of bill amount. where a person neglects to pay any charge for electricity or any other sum due from him to a licensee by the due date mentioned in the bill in respect of supply, transmission, or distribution or wheeling of electricity to him, the licensee may, after giving not less than 15 clear days, very important, my lord, not less than 15 clear days notice in writing to such person and without prejudice to his rights to recover such charge or other sum by suit, cut off supply of electricity until such charge or other sum, together with any expenses incurred by him in cutting off and reconnecting the supply, are paid but no longer. Now, we have, this is the 8.2 from the AERC. Now, this has to be read in consonance with section 56(1) of the Electricity Act. The same is reproduced on the next page.
Yes, please.
Here, the disconnection notice which they claim was included in the bill itself is reproduced herein. The portion which is in bold, disconnection notice. Under section 56(1) of the Electricity Act 2003, power supply to your premises will be disconnected at any time due to non-payment of arrear amount. Well, this is the language that was used. I shall refer to the said bill at the later stage, but this is the language that was used. Here, they've clearly stated that they are relying upon section 56 of section 1 of the Electricity Act, but the latter portion of the said notice, purported notice, states that it can be disconnected at any point in time, my lord. However, your lordships will recall that the Electricity Act, along with the AERC, clearly stipulate 15 clear days time, my lords. 15 clear days time.
Yes.
Now, so my lords, here, the learned single judge, my lord, recorded in the impugned judgment and order that their submission, their contention that the said disconnection notice was included in the bill itself was enough to constitute compliance of section 56 and section 8.2 of the AERC, my lord. That is the first finding that we're challenging. Now, our contention before this appellate court, my lords, is that the contention of the respondents cannot be accepted in any form whatsoever due to various reasons. The first reason is that, my lord, our contention before this honorable court is that the notice under section 56, along with 8.2 of the AERC, has to be furnished separately, and cannot be included in the bill itself. Now, I'd like to rely upon a judgment that has been passed, my lords, in this regard.
What is the citation?
Yeah, I'll get the citation. The citation of the same is AIR 1987 RAJ Act. Extra copy. But here, if your lordships have the copy. Here, my lords, this is with regard to the earlier Electricity Act. The new one came into effect in 2013. This is with regard to the earlier one. And this is regarding section 24, which is paramateria to section 56 of the Instant Act. The language is also clear. The only difference between the section 24 of the previous act and section 56 of the current act is that in the previous act, the notice was to be served for 7 days. However, in the current act, it has been extended to 15 days. I'll take your lordship to the relevant portion directly, your lordship. Paragraph number 7. Paragraph number 7. Your lordships have it. I'll read it out. I have given my most earnest consideration to the submissions made by the parties. Section 24(1) of the Electricity Act provides that where any person neglects to pay any charge, your lordship may kindly appreciate that the language is the same, neglects to pay any charge for energy or any sum other than a charge for energy due from him to a licensee in respect of the supply of energy to him, the licensee may, after giving not less than 7 clear days notice in writing to such person and without prejudice to his right to recover such charge or other sum by suit, cut off the supply, and for that purpose, cut or disconnect any electric supply line, or other words, being the property of the licensee. So here, my lords, your lordship may kindly notice that 7 days clear notice has been given under 24. Now, what was the finding of the Honorable Court in this case? The last but one paragraph, paragraph number 10 may kindly be seen. The ratio has also been laid down, my lords, here. It is true that Rule 25C of the General Conditions of Supply says that if the consumer fails to pay the bill, the board shall be at liberty to cut off the supply without giving any other notice under Section 24(1) of the Act of 1910. But this rule is definitely against the express provisions of Section 24(1) of the Act of 1910, which provides that where any person neglects to pay any charge for energy to a licensee, his power connection can be cut after serving on him a notice in writing addressed to the consumer, delivered by hand, or pasted at his premises, or sent by registered post. Now, your lordship may kindly come to the last but 6th line, my lord, towards the right-hand side. Last but 6th line. If the bill is lost, your lordships have it. If the bill is lost in transit or even not sent, or the consumer is unable to know the exact date of the meter reading, then it could never have been the intention of the legislature that even under such circumstances, his power connection may be cut without even affording him an opportunity to submit his side of the case. Section 24(1) of the Act of 1910, therefore, clearly envisages a separate notice in writing after the default, my lords. I'd like to emphasize on this and repeat again. Section 24(1) of the Act of 1910 therefore clearly envisages a separate notice in writing after the default. Yes, ma'am. So that is our first contention. In line with this judgment, and after a thorough reading of Section 56 as well as 8.2 of the ERC, it becomes amply clear that a notice can only be served after the default has been committed, my lord. The default, by default, I mean when the petitioner or when the consumer does not pay the due amount till the last date. Only after that point can a notice be issued. Now, they say that it is included in the bill itself. Now, how could they possibly foresee a circumstance or a contingency where that a person would not pay the amount, and therefore the same would come into play? That cannot be that could not have possibly been the intention of the legislature, my lord. That is my first contention. Now, the second contention also, I'd like to refer to the AERC supply code, my lord, the regulations itself. In the written submissions itself, my lords, your lordship may kindly come to the supply regulations at page number 28. Page number 28. The lordships have it.
Yes, please.
Page number 28, General Provisions, Chapter 10 towards the end, 10.3, Service of Notice. This will also clear the position as regards how a notice is to be served and what its contents should be. 10.3, Service of Notice. Any order, oblique, notice, oblique, document to the consumer by the distribution licensee, including the notice under Section 56 of the Act. Again, my lords, including the notice under Section 56 of the Act, shall be deemed to be duly served if it is, number one, sent by registered post or speed post under certificate of posting courier at the correct postal address of the addressee with acknowledgement, or next page, point number 2, delivered through special messenger to the person residing at the address, notified to the distribution licensee by the consumer, and obtaining signed acknowledgement. Provided that in the case of so-and-so, that is not relevant. So here again, my lords, we see that a specific procedure has been laid down by the statute itself as to how that notice is to be served. So at the very first instance, I'd like to submit that nowhere is it mentioned that it can be included in the bill, but even assuming that such a restriction does not lie, the service of the said notice is quite different from how a service of a bill is to be done, my lords. A bill can be laid at the doorstep of the consumer. But here, the notice, there's a specific procedure that has to be followed, and that has not been followed in the instant case, my lord. That is the second leg of my argument with regard to my first contention, that the notice itself is not duly served under the provisions of the said act and the regulations. Now, the second contention that I raised before this honorable court is that let us come to the said disconnection notice, the purported said disconnection notice itself, the counter affidavit filed by them before the learned single judge, which is annexed at page number 77. There are a number of documents that have been annexed, but I'll refer to 77 as one of the sample ones. Page number 77.
It has two parts.
Malad.
It has two parts.
Yes. 77, your lordship may kindly come to the middle portion under disconnection notice, left side, disconnection notice.
Yes.
Your lordship may kindly see disconnection notice. Your lordships have it. Here, let us read the language of their purported notice. Under section 56(1) of the Indian Electricity Act 2003, power supply to your premises will be disconnected at any time. At any time due to non-payment of arrear amount, ignore if already paid. The act itself, section 56(1) lays down 15 clear days. The AERC 8.2 lays down 15 clear days. But the respondent authorities include this language saying that it can be disconnected at any point in time. If this is not illegality, then there possibly could not have been any other illegality. So this is the purported notice that they rely upon. This is the second one. Now, I'd like to take your lordships to the facts of the case. The notice, sometime, I'll take your lordship to page number 45, annexure A1 of the writ petition, annexure 45 of the paper book. Sometime in 2022, an associate of the petitioner approached the respondent authorities regarding the disconnection of the disconnection of the electricity connection. And it was intimated to them that the day that he had approached the authorities, which was 29th of March, 2022, was the last date for submission or for payment of the arrears, for payment of the dues, my lord. At page number 45, your lordship may kindly notice, top side, right-hand side of the bill amount 18,358. Your lordships have it. The next line, due date 29 March 2022. It's very important. Due date 29 March 2022. After that, it does not end there, my lords. 3 lines thereafter, number of days 42. The next line, meter status running. Meter status running, your lordship may kindly notice. It says meter status running. And the next line, billing status normal. So, 2 things I'd like to note from here. First, due date 29th of March, and number 2, meter status running. And this is on 29th of March, my lord. Now, let us see on the next page. On the next page, page number 46, on the right-hand side, your lordship may kindly notice, date 29 March, the same day itself, 29 March. 29 March, name so-and-so, left side, this, at the heading may kindly be seen, energy bill payment receipt. So on that day itself, the last day itself, the due was cleared. This is the receipt. The next page. Now, when we cleared the receipt, the respondent authorities informed us that temporary connection had taken place and that we would have to pay a certain amount for reconnection. On the next page, page number 47, your lordships, page number 47 is the amount that we paid for reconnection. Page number 47. So rupees 600. Rupees 600, my lord. This is, so at page number 46 is the payment receipt of the arrears and dues, and page number 47 is the reconnection payment that we've already done on the last date itself, my lord. On the last date itself. And your lordship may kindly recall that the last date was 29th of March, according to the bill itself. Now we made the payment, we paid the reconnection dues as well. And even then, the connection was not restored. May I continue, Your Lordship?
Just a minute.
Hello.
Yes.
Well, after that, what happened was we were informed that temporary disconnection had taken place long back, my lord. We were informed that temporary disconnection had taken place in 2020. So I'd like to thematize my arguments. The first argument was that no notice was issued in the first place. Second, even if it is assumed that the procedure was correct, the notice itself is defective because 15 clear days were not given. The third contention is that, my lord, despite taking the reconnection fees and repayment of our dues, they still did not restore our connection. Now, I'd like to take your lordship to the regulations again. Because a number of illegalities were committed even after disconnection also. At page number 24 again, my lords, of the written submission is the disconnection. At page number 26 is the relevant portion. At the very outset, my lords, I'd like to make a clarification that the Electricity Act does not envisage any concept of temporary disconnection. It only talks about disconnection. It does not talk about temporary or permanent disconnection. The nomenclature of permanent and temporary disconnection has been introduced in the regulations. Now at page number 26, this is in continuation of the temporary disconnection portion, my lord. At the very top, second paragraph, your lordships have it. If I may read it out. The licensee shall intimate the consumer in case of his temporary disconnection in format 18 of this code within 24 hours of disconnection. Within 24 hours of disconnection. The legislative intent behind this is that, my lords, the consumer has to be made aware that his electricity connection has been disconnected and an opportunity still vests with him to repay back the arrear amount so that he can pay it and then restore the connection before permanent disconnection takes place. Therefore, this provision has been introduced whereby it has been mandated that a notice after temporary connection is tendered to the consumer. Now, let us, I apologize, I'd like to take your lordship to another document that has been annexed by them at page number 85 of the paper book. Now, this is the purported notice which they say they serve to us after disconnection. So again, quickly refreshing, my lord, a notice before disconnection is mandatory, after also is mandatory at page number 85. Page number 85, my lords. Your lordship may kindly notice the date first. Date towards the right hand side, 16/11/2021. 16th of November 2021, my lords. Now, let us look at the body, the second paragraph. This is to inform you, my lords. Your lordship may kindly see.
Just a minute.
Yes.
Okay.
Yes. Your lordship may kindly see. This is the format 18 notice that they claim to have served to us, dated 16th of November 2021. The body. This is to inform you that your supply, your lordships have it. This is to inform you that your supply has been temporarily disconnected with effect from 20 August 2020. 20 August 2020. The AERC says that this notice has to be served within 24 hours. They did not serve, they served after more than 12 months, my lords, altogether. This has to be served after within 24 hours, and this is their own document. And this again, we are disputing because they never served it to us. And before the learned single judge also, we pressed this argument that let them produce proof of service, which they could not produce. They never produced any service, proof that it was service to us, which we dispute again. But even if we assume that it was in fact service to us, their own document shows that this notice is dated November of 2021, while they claim that the temporary disconnection took place in 2020. This is the fourth illegality, my lord. And at this juncture, my lord, I'd like to draw your lordship's kind attention to the judgment rendered by the Honorable Apex Court in Babu Varghese, where the Honorable Supreme Court said that if a procedure is laid down in a statute, then it has to be conducted in that manner or not at all. So here again, my lords, your lordship, this is clearly in violation of the 24 hours quota by a long, long margin. Again, let us go back to the AERC again, my lords. The same place, page number 26. What does it say? After, at page number 26,
Yes, please proceed.
8.2.3, reconnection or restoration of power supply. Lordships have it. If any service is disconnected on account of non-payment of electricity charges or any other charges due to licensee, the consumer has to pay the charges for disconnection and reconnection, which your lordships will recall that we had already done on 29 itself. The licensee shall restore the electrical supply within 24 hours in urban areas and within 48 hours in rural areas after the consumer has produced the proof of payment of charges by consumer or compliance report on removal of any defect or discrepancy. However, restoration of power supply will be attended to only between so-and-so, except in cases of supply so-and-so. So what this provision states is that once the consumer has paid the due amount and the reconnection charges, then the electricity has to be restored forthwith, which again has not been done in the instant case, which again has not been done. Now, after this, your lordships, they say that since we did not pay the amount after temporary disconnection, they permanently disconnected our connection. Now, let us go through the provisions of permanent disconnection as laid down in this statute itself. 8.3, page number 26, last part.
Yes, please.
Last part, permanent disconnection. The supply shall be disconnected permanently in following cases, so and so, my lord. Now, provided that if the service of the consumer remains continuously disconnected, so and so, my lords. Now, the latter part, after termination, that's last but one line of this paragraph. Page number 27, the fourth line. After termination of all agreement, the licensee shall intimate the consumer in the format 20 of this code. Shall intimate. Shall. This is mandatory. This is not discretionary or directionary in nature, my lord. This, again, they have not done. Before the learned single judge also, my lords, we made specific averments that this format 20 notice was never served to us, and they were directed to produce records in relation with this matter, which they never did. Till today, we asked them, show us the permanent disconnection notice. The provision states that it has to be done. Shall intimate. Format 20. Yes, Lord. The format 20 notice. Till date, my lords, we asked them to at least hand it over to us, my lord, which again they have not done. So, lordship, now, before the Honorable Learned Single Judge, my lords, we stake a claim that our claim we would be satisfied if they restore our connection, to which they said that it cannot be done because they had removed the meter. They had removed the meter before 29 March. It is part of their reformance, my lords. Now, your lordship will notice the very first bill that I drew your lordship's attention to, the last date was given as 29th of March. How could they possibly have removed the said meter before 29 March, my lords? Till 29 March, my right still subsists. Only after 29 March can they take action. Now, they say that they cannot do that because they removed the meter altogether. But the regulations itself gives provision for reconnection and resupply of the said electricity connection modes. And also, how could they claim that they have removed it when the bill itself states that the status of the meter is running? In the bill itself, the status of the meter is shown as running, but they say in their affidavit that they've already removed the meter. There has to be some end to the illegalities that the respondents are committing. So, these are our broad contentions. And again, we'd like to rely upon Mohinder Singh Gill versus Election Commission of India also, wherein it has been clearly held by the Honorable Apex Court that no plea or contention can be raised by a party which is not part of the impugned order, my lords. They cannot be allowed to supplement their affidavit. And again, going back to Babu Varghese, my lord, if a procedure is laid down in a statute, then the said process has to be undertaken in the said procedure in the manner only or not at all. And in the instant procedure, I'd like to quickly thematize, my lords. Number one, no notice has been served because it has to be served separately. Number two, even if we assume that it has been served, then the notice is defective because it does not give us 15 days clear time. Number three, even after temporary disconnection, the 24 hours mandatory format 18 notice was never served. Number four, no notice after the permanent disconnection also served. Number five, how could the disconnection have possibly taken place before the due date? And number six, we made all the payments. We cleared our dues, we cleared our arrears, we also paid the reconnection fees. Even then, how could they possibly not do it? But those are my contentions, and I'd like to, if your lordship is satisfied,
What is the finding of the learned single judge?
your lordship may kindly come to the impugned order, my lords. Yes. At page number 52, page number 51 is the impugned order.
Just a minute.
The
Absence of
Yes, Mr. Sahu, which page?
yes, but the impugned order
Hmm.
is at page number 102, the first page. Annexure 6. 102.
Yes.
The relevant portion regarding the disconnection notice. Let's
is at page 106, my lord.
para 10 minutes.
107, disconnection notice heading.
Yes, my lord. Your lordships have it, my lord. The petitioner in person had submitted that there is a legal requirement of serving a separate disconnection notice under section 56 prior to temporary disconnection and permanent disconnection. It was submitted that the statement made in the energy bill regarding disconnection notice under section 56(1) of the Electricity Act 2003 would not constitute due service of disconnection notice. It was submitted that by not issuing a separate disconnection notice, the right of the petitioner to natural justice has been violated. We are unable to accept the said contention of the petitioner in person. An electricity consumer cannot claim that he does not know the billing cycle and that he has a duty to pay electricity bills timely to have continuous electricity energy supply. Therefore, the statement in the bill for current electricity charges regarding disconnection notice by mentioning that under section 56(1) of the IE Act 2003, power supply to your premises will be disconnected at any time due to non-payment of arrear amount, ignore if already paid, in the considered opinion of the court, would constitute due service of a disconnection notice. The respondents have enacted the temporary disconnection notice issued to the petitioner on 16/11/2021. Again, my lords, here, the learned single judge lost sight of the fact that the said format 18 disconnection notice was not served within 24 hours. Was not served within 24 hours. And the learned single judge also lost sight of the fact that, my lords, the notice, if we cannot work on the presumption that a person knows the billing cycle and therefore no notice is required because he is expected to comply. If that were the case, my lord, then I'd like to take the example of section 138 of the Negotiable Instruments Act. The person knows that he issued a check. then the check got dishonored. Then what is the necessity to issue a notice, my lord, for section 15, for 15 days? The legislative intent was clear that even though you are aware that your check has been dishonored, we will still give you 15 days time to honor that, my lord. That is the provision, that is the legislative intent behind the provision for issuance of notice of 15 clear days in Negotiable Instruments Act. The same logic can be imported in this statute as well. Even though the single judge says that the consumer knows when he has to pay, very well, let that be assumed to be true. Even then, the statute lays down 15 clear days time for them to clear the dues, my lord. That has been lost sight of by the learned single judge. Now the next parts, my lords, if a lordship, if I may read them out, my lords, or
Just point out.
yes, my lord. Analysis. Page number 108, paragraph number 12, my lords. Analysis of materials on record to ascertain to what relief the petitioner would be entitled to. Paragraph 12. It is seen that along with affidavit in reply, the petitioner has produced a copy of letter dated 8/4/2022 by SDE Subdivisional Engineer, Zoo Road Electrical Subdivision, which was in response to the advocate's notice dated so-and-so, by which the petitioner was informed that electricity supply to his premises was permanently disconnected on 14 March 2022. The due date on the bill was 29 March. And they say that they disconnected it on 14 March 2022, 15 days before the due date. However, in the body of the said letter, there is a handwritten note which appears to be made by the petitioner mentioning that this is reply to the legal notice. It clearly demonstrates that notice, if at all, was given only on 16/11/2021, whereas it was temporarily disconnected on 23/2020, for which no notice was given. Thus, it appears from the document produced by the petitioner that electricity energy supply was disconnected to his premises on 23/2020. Hence, as per the document produced by the petitioner, the permanent disconnection was done on 14 March 2022, was far beyond 180 days as prescribed by regulation so-and-so. And a slew of sections, provisions have been reproduced by the learned single judge, my lord.
Judgment has been referred.
At page number 112, my lord, the relevant portion, I'd like to take the lordship to the operative portion. Paragraph number 21. Thus, the court is inclined to hold that the issuance of PDC bill dated 14 March 2022 cannot be said to be illegal. Moreover, the court is also constrained to hold that the payment made by the petitioner on 29 March, again, the date's very relevant, 29 March 2022, for a sum of rupees 18,000 towards energy charges and rupees 600 towards reconnection charges would not entitle the petitioner for restoration of supply through the permanently disconnected electricity supply meter or so-and-so. Under the circumstances and in view of the prescription of the Electricity Act 2003 and AERC Supply Code, which are referred and discussed above, the case of Mamta Mohanty, Supra, which was cited for the legal proposition that if an order was bad in inception, it does not get sanctified at a later stage, would have no application in this case. Paragraph number 24. The petitioner has admittedly paid reconnection charges. So, we are in appeal, they are not in appeal. Therefore, they have accepted this proposition that the finding of the Honorable Learned Single Judge is binding, that the amount of 600 was in fact reconnection charges. The petitioner has admittedly paid reconnection charges to the respondents on 29th of March 2022, which was not restored. Therefore, the court is inclined to hold that the petitioner would be entitled to adjustment of the component of reconnection charges that may be left after the disconnection charges is adjusted and or apportioned by the respondents. The reconnection charges should be adjusted by the respondents against the energy supply bill, which would be issued after fresh electricity energy connection is provided to the petitioner. However, if the petitioner does not apply for a fresh so-and-so millers, therefore, in light of the discussions above, this writ petition stands partly allowed to the extent of the relief as granted by the observations made in paragraph 24 millers. All other reliefs as paid for by the petitioner is refused. So this is the finding of the learned single judge. The learned single judge records that the payment was made on 29 March. The learned single judge also appreciates that the due date was 29 March. The learned single judge also recorded in the judgment that the permanent disconnection took place on 14. But logic would dictate that the permanent disconnection can only follow after the due date. Despite that, the prayer has been declined. And the question of issuance of PDC bill, my lord, issuance of PDC bill. They say PDC bill, permanent disconnection bill. The proposition of PDC bill has been accepted by the learned singles. Our contention is, my lord, how can it be accepted when this mandatory and statutory requirement of issuance of format 18 and format 20 notice have not been complied with? When they've not been done, how can a PDC notice be acceptable, my lord? And again, I'd like to impress upon this honorable court that the format 20 notice has still not been supplied to us, still dead, my lord. Before the learned single judge also, we raised this contention. They were always at liberty to produce the same, till date have not done so, my lords. And therefore, again, Babu Varghese is clear, my lords, when there has been a violation or any departure from the established norm, then the entire procedure is required to be quashed and set aside. That would be my contention before this honorable court. But before parting with my submissions, I'll just like to draw one small parallel, Millers, with that happens with what happens in service matters also, Millers. Your lordships are more than aware that Millers, when an employee joins an organization, a state authority, Millers, they in their contract itself, it is amply given that if they perform their duties in contravention of the intention of the organization, then their service may be terminated. Does that mean that whenever there is any deviation in their conduct, without issuing show cause notice, the service will be terminated? Absolutely not. Even though it is included in a contract that if there is any deviation, they may be dismissed. But the principles of natural justice dictate that a show cause notice be given. In the same manner, here also, my lord, only after default can a notice be issued, and the purported notice included in the bill cannot be subsumed into the compliance of Section 56 itself. Thank you, Bloods.
Mr. Sharma, Yes, my lord. Please come to page number 45. Just explain it to us. We want to move from it.
Yes, my lord. My lord, this is a permanent disconnection bill, my lord.
What if we're not? Please come. Area principal is there.
Yes, my lord.
Link it. Area surcharge is 2010.52.
Yes, my lord.
This is on what basis?
That is current charges.
No, no.
Yes, my
Area
lord.
surcharge and current surcharge.
Yes, my lord.
Now, what is area surcharge?
It is the area charges of the previous bills which have been accumulated.
What is the some kind of 10%,
Yes.
5%? Where from will you get it?
My lord may look at my affidavit in opposition. 77, my lord.
77. How do you calculate it?
My lord, by calculating the area principal, my lord, of every bill.
What is certain kind of percentage is there, right?
Yes, my lord.
What
And
is the
for that,
percentage?
I'm trying to take my lord to page number 77.
Hmm.
My lord may see area principal 1730.77.
Hmm.
My lord, then my lord, at the second bill, my lord may see it has been raised. Area principal 2641.92 and searches is 20.51.
No, no. Kindly come to page number 40. It's a different bill altogether, right?
Yes, my lord. These are after these bills, the 45 page number 45 bill has been issued.
No, no. That is why we want to know. Yes. Area principal is 16143.15.
Yeah, that is accumulation of all the previous bills which have not been paid.
Right. Now, what is surcharge? What is the percentage of surcharge?
My lord, the percentage of charge will be
How do you calculate this?
that will be at 8.20, my lord. From the first bill, you may 8 rupees has been charged on 1730. So it will be very minute percentage.
There must be some kind of percentage or something like that.
Very minimal, my lord.
You have the entire bill because backside of the bill normally reflects those things.
My lord, may I just take up to the case once? It will help my lord to understand. My lord, may I just see my page number 77 once.
Yeah, there at least.
So yes, my lord may see that here the energy charges are there, fixed charge is there 794, and my lord may see area principal is there. And my lord may see here that current demand 928, outstanding amount 7398, net bill amount is 2667.
Hmm.
At top, my lord.
That is what we want to know from you.
And my lord may see here units consume metering penalty at the rate 3% at top. At top of that, my lord. Metering penalty. DTR penalty 10%, HT rebate 3%. Units consumed. After that, my lord, LT metering bill.
What is DTR penalty?
Direct transmission rate penalty, my lord. That is not that is not applicable. That will not here LT metering, lower transmission metering penalty, DTR penalty, and high transmission. Here lower transmission metering penalty will be applicable at 3% because it's a low transmission line. It's just a normal home connection.
Yes.
So my lord, may I just place my case here once? My lord, what was the case of the petitioner here is that he has been saying that we never served upon him the notice. In fact, the interim order that was granted by this honorable court was that only thing that had to be find out whether section 56(1) has been complied or not. Now, my lord, first of all, the judgment which my learned friend has been referred, it's a single bench judgment of Rajasthan High Court and 1910 Electricity Act and rules of Rajasthan State Electricity Supply Code, not applicable to us, and even it cannot have a possessive value. So, my lord, section 56(1) says 15 days. Now, at the top of the bill, there is a due date, which says, page 77, my lord, 16/6/2020. And there is a bill period, 1/5/2020 to 1/6/2020. So, that's a bill period, and there at top is a due date, 16/6/2020. Topmost corner, right? So the 15 days period as per section 56(1) is already be inscribed in the bill. That is 16/6/2020. And that's why that is a particular reason, my lord, that it says under section 56(1) of the IE Act, Power supply to your point will be disconnected at any time due to non-payment of area amount if ignored if already paid.
Mr. Sharma,
My lord.
just clarify two things for me. Why fixtures is collected?
One of fixed charge is fixed charge is collected as a rate or the particular rate on which the electricity is given. The definition of fixed rate is here at the AERC code. I'll take to that, my lord.
Just tell us fixture.
Shall be the provision of the tariff order issued for the licensing of the commission. Because, my lord, it's a commission which the Assam Electricity Regulatory Commission is there. So for every electricity consumption, there is a fixed charge that we have to pay to the government. That is the fixed charge. That's 42, the definition is there. Shall be as per provisions of prevailing tariff order issued by the licensee by the commission. Page, my lord, if my lord has this, I have given the code. So this fixed charge is for everything because my lord may see over there, the energy charge is 0. My lord, see 7.40 unit amount is 0. It's only the fixed charge been there. 794, that is 6 units, 130 per unit, and that's 794.
After 28th of August
After 28th of August.
2020,
Yes, my lord.
how many bills you have issued to the writ petition?
We have issued him bills, my lord, till we have issued, my lord may see at page 85. It has been very much clear. This is to inform you. Yes,
I wanted to know from you,
yes, my lord.
up to which date you have issued him bill?
My lord, it has been billed till 27/8/2021, my lord. 27/8/2021.
Thereafter, you have not issued any bill?
My lord, thereafter the PDC comes before issuance of 16/11/2021.
No, no,
The moment we have issued.
no, that
Yes,
is
my
the
lord.
reason we are asking you.
Yes, my lord.
You have permanently disconnected, right?
My lord, that is where the confusion has been laid down by the.
That is why we are out to know.
Yes, my lord.
Temporarily disconnected on 28th of August 2020.
No, my lord, that is your supply has been temporarily disconnected with effect from 28th August 2020.
And permanently disconnected.
Permanently disconnection will thereafter take after within 40. If the cause of disconnection is not removed, the satisfaction of this of an above amount is within 45. Your supply will be disconnected permanently without any further notice. This is the format 18 notice.
Please come to page 86, your communication.
Yes, my lord. 14 March 2020, my lord. 14 March 2022.
That is what we want to know.
Yes, my lord.
After
My lord, may I just take, my lord, the confusion, I'll able to clear it, my lord. My lord, may just see page 85 once. Page 85 once, my lord.
Yes.
Yes, my lord, page 85. My lord, may see, this is to inform you, your supply has been temporarily disconnected with effect from 20th August 2020. Due to the following reason, non-payment. You are requested to remove of cause of disconnection, intimate this office at the earliest. You are also requested to pay a sum of rupees 13,000 towards disconnection and reconnection charge. If case the disconnection is not removed to the satisfaction of this office and above amount is not paid within 45 days of this notice, your supply shall be disconnected permanently. Thereafter, we intimated them on 8/4/2022. After the 45 days, as per the format 18, has been lapsed. Was permanently disconnected on 14 March 2022. So the time period here is that in the year 2020, my lord, he has not been paying his bills. Normal bills were raised to him. After normal bills were raised to him, we did a permanent disconnection. We took the provisions of temporary disconnection. My lord,
That is why I wanted to know from you, up to which date you have been issuing him regular bill.
my lord, we have been issuing, that has been very much clear, my lord. We have been issuing regular bill to him
But if I may,
27/8/2021, my lord.
27,
8/2021,
27, 8,
2021.
but you have temporarily disconnected him on
20th August 2020. My lord, the moment the 15 days, my lord, when the electricity bill is given,
when temporarily disconnection is made, what happens?
when temporary disconnection is made, so what does the consumer does? He goes and pays the due amount. Moment he pays the due amount, reconnection is again takes place. Reconnection charges takes place. Now, what has happened in his case? From
No. If let's forget about his case.
Yes, ma'am.
Temporary connection means you cut off the connection from the pole.
no temporary disconnection is with temporary connection, we disconnect the connection to his meter. We connect the disconnection to his meter. We basically there are some socket there. We just remove it. Nowadays there is a smart meter is there. The automatically when the bill is not paid, it's been disconnected. Some similar like that.
No, that is the reason. To disconnect the connection
Yes,
to the meter.
yes. Temporarily,
To temporarily disconnected the connection.
the connection is
supply-
disconnected. Yes, my lord.
Electricity supply is stopped
Yes,
to the meter
yes.
so that he cannot consume any.
Electricity
Now that is temporarily.
disconnection.
And when you permanently disconnect, what happens?
We removed everything. We removed the entire meter. The entire thing is removed from there. The entire meter, everything is there, has been removed. So now the one my lord would ask me why the status running has been shown.
No,
That-
we're not on. So the process of temporary disconnection
Yes, my lord.
was in force from 28th of August 2020
Yes, my lord.
up to 14th of March 2022.
My lord, this is to inform you, it was discovered with effect from 20th August 2020. And it was up to the point that 16/11/2021 notice was issued. Till that time, the temporary disconnection was there. That is why format 18 was issued to him on 16/11/2021 and 45 days was given to him.
16/11/2021.
And that is why the PDC bill of 2022.
Now 16/11/2021 is the
Format 18 notice.
format notice regarding the temporary disconnection.
Yes, my lord.
Thereafter,
Thereafter, my lord, see, at bottom, if the cause of disconnection is not removed to the satisfaction of this office and above amount is not paid within 45 days of this notice, your supply shall be disconnected permanently without any further notice.
16/11 to 16 December
Yes, my lord.
and then up to 1st of January 2022.
Yes, my lord.
45 days is over.
Yes, my lord. And accordingly, my lord, may see the PDC bill is of 1st February to 14 March 2022.
Why 1st March of 2022?
1st Feb, my lord. 1st Feb. Bill period is from 1st Feb to 14 March 2022.
Have the regulation tomorrow, it will ask you something.
Yes, my lord. I've got the regulation right now, my lord.
Tomorrow at 2.
Yes, sir.
Okay. Adin list on that. Just put in back 2.
Much all right.